All right, who's here on Fernando Trillo?
Your Honor.
All right, my understanding he's still in federal custody,
October the 27th, this is jury trial date.
October 27th.
Yes.
And on this, do you have all discovery?
Yes, ma'am.
All right. And it is up now. Just 1 second. Do you remember if you? Oh, awesome. You guys remember if you filed a acknowledgement of discovery? Has that been done in this case? Okay. Does he have more than one case?
2 cases, Judge, I believe.
I have a felon in possession. He's got aggravated.
Okay. All right. Do you guys have any idea how long you think maybe the federal case trial will last if it actually goes?
I think it's probably gonna be said, get tried in January, February sometime.
He would know more than I do.
Okay. All right, Ms. Ferguson, can you put this like the second week of November and we'll see where we are.
I can do the 10th, November.
That's fine.
All right, November 10th.
Great, thank you, Judge.
All right, thank you.
And Judge, I have someone else, Stacy Smith. So
Stacy.
we're awaiting evaluation on it.
All right, if you'll let them know so they can tell me what page she's on.
Yeah.
Oh, no.
I'm just.
And it's
Stacy Smith.
Judge at the bottom.
We're back on.
And you say what's
Still
going
waiting evaluation. Psychiatric.
Okay, so
All right, Norma. On Stacy Smith, do you know when her evaluation is scheduled for in magistrate's court?
Let me check. They're waiting on the report, Judge, and it looks like she hasn't received maybe the report until September 16th.
All right, so set this for the end of September.
Yes. I can do September 29th.
All right, thank you.
Maybe.
Do you want to speak to her?
No, I've spoken, I think I spoke to her a couple of weeks ago.
All right. All right, Deputy Laura, you can take her back. All right, so anytime you have someone, if a defense attorney suggests that someone is incompetent, which means they don't know what they're charged with in layman's term, they don't understand the consequences of entering a plea, they don't understand the consequences of a trial. Once a defense attorney presents just a scintilla of evidence that somebody may be incompetent, you have to have them evaluated, and you can't continue with your proceedings until you get the results of that evaluation. And so once that evaluation is done, if they say that the person is incompetent, then they'll either go to a state hospital, and legally, if it's a violent offense, they're supposed to go to the state hospital. But if it's non-violent, normally they will have them do it on an outpatient basis to regain competency. But once they regain competency, if a defense attorney wants them evaluated for sanity, then what will end up happening is, one, they must get an evaluation for sanity. I can't say, oh, you're not getting an evaluation for sanity. According to the law, they're entitled to one. And so the best way to remember it in the way that I tell students, competency is your mental state currently. Sanity is your mental state at the time of the offense. So, all right, so this next case I'm here, they want to, the state has filed a motion, not the defense attorney, the state is filing a motion. And they're saying they want this person's bond conditions to change because whoever set the bond, it wasn't me. They didn't put any conditions on him. So they want certain conditions like no contact with the complainant, which is pretty standard. All right. Who's here on David Lopez?
I am, Your Honor.
Yes. So if you can come forward, and where's Mr. Lopez? All right, Mr. Lopez, if you'll come forward. We're just here for a bond issue.
Yes, Your Honor.
So they're just here for a bond issue. This case is actually set on September 23rd for discovery. So anybody can file motions at any time and request that they be heard. So that's why it's on the docket. All right, so they're asking for no contact. Before we go on the record, do you have any objections to a no contact order?
Absolutely, Your Honor.
All right, so we'll go on the record.
Thank you.
All right, the court is calling 2025 CR 001961 State versus David Lopez. Could I have parties announced for the record?
Ashley Jones for the state.
And Eric DeWalt, and I represent Mr. David Lopez.
And are you Mr. Lopez?
Yes, ma'am.
All right, so we're here because the state has filed a motion for a no contact order as a condition of bond. They're stating that the judge who entered the bond did not place any conditions on you as a condition of bond. The state is asking for no contact with the complainant. Is that the only request?
At this time, yes.
All right, so, and off the record defense, you said that you were opposed to that.
I am, Your Honor.
All right, are there any witnesses?
No, Your Honor.
All right, the court will hear argument. So they,
Possibly, if need be, witnesses.
That's
Sorry, from the defense.
all right,
Need be.
it may need be.
I
All right,
understand.
all right. So do you have any witnesses to call today or no?
The state does not.
Okay, then I'll call Sue Lynn King.
Okay.
We hear through.
All right. Can you raise your right hand?
Fine.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you'll state your name for the record and spell your last name.
Sue Lynn King, K-I-N-G.
All right, you may proceed.
Ms. King, I was appointed to represent David Lopez, and you understand what he is charged with, is that correct? He's charged with aggravated sexual assault of a child, and you've seen the indictment. He's also charged as a repeater, is that correct?
Yes,
And have we talked about that repeater allegation?
yes,
Have you seen the judgment of the repeater allegation?
yes, I have.
And is the picture in the judgment of David Lopez?
No,
Is the date of birth of David Lopez?
no,
Is the height of David Lopez?
no,
Is where he served and he was ultimately found guilty in Harris County? In your knowledge, has David Lopez, your David Lopez, ever been to Houston?
he's been to Houston, but he never lived in Houston.
Has he ever been to prison?
No,
Okay, so the repeater, when he got placed on bond, this bond amount reflects an aggravated sexual assault of a child with a repeater allegation, correct?
yes,
And he's out on $100,000 bond?
yes.
How did that?
I'm sorry, just on my, excuse me. Did you print out the? Thank you.
If you-
Ah. I have a copy, no problem. Thank you. All right, you may continue.
Now, you understand the allegation against David Lopez, is that correct?
Yes, sir.
Who is the alleged victim in this case?
My granddaughter.
And you took over custody of your granddaughter. Why?
They were in foster care due to
Let me stop. They, who's they?
all three girls.
Okay, so there is Phoenix, and she's the oldest.
Uh-huh.
There's Annabelle.
In 2016 and brought them to Texas from Tennessee due to their grandmother and her brother molesting them. They were taken into state custody. Phoenix came out with a lot of issues psychologically. He was in counseling from the beginning and is still in counseling.
You have dealt with CPS on multiple occasions, correct?
Yes, they were always in my home at the time the girls were brought in.
But you have complied with all of CPS's requirements, safety plans, and anything. You've always been available to speak with them, correct?
Always.
Okay, and it was CPS that allowed David to come back to the house, correct?
Yes, it was.
Now, at any time or on multiple occasions, did Phoenix recant her story?
Multiple times to me, and then she had she went back to child save and recanted all of it.
Just one second. Let's pause for a moment. Because I have an idea that she's going to say that she wants him there. She doesn't want the no contact order. So does anybody have any way to have the CPS worker zoom in?
The state can speak to that. We do have CPS records. I have reviewed them in full. CPS, I guess, their concerns were illegal because cameras were put up in the homes.
Well, no, I mean, does anybody have a CPS worker to zoom in? for me to listen what the CPS worker has to say?
No, I just
Is
have our
that possible?
CPS report.
No, Your Honor. So I can.
All right, and then with regards to the indictment, sorry to interrupt your cross, but these are questions as I'm hearing a testimony that I would like answered. With regards to the indictment, is the indictment correct?
No, Your Honor, there is an incorrect birth date on the repeat offender enhancement, so the state would be filing a motion to amend the indictment to.
And have you all had a chance to speak to the complainant?
We have, Your Honor, and this in raw record.
Yes.
Okay, the state's concern is that the complainant has been with the defendant in the home for the past year and a half. And so speaking with the child under those circumstances isn't ideal.
Okay.
And if I may, Your Honor, speaking off the record, like the state, I've talked to the state. They filed this motion to amend conditions while getting ready for trial. And I believe Ms. King went and talked to them, took Phoenix in after. I've spoke to the state. I think the state told Ms. King, I doubt the judge will rule on this, but I know how severe this is. CPS let him back in. They put up multiple cameras
17 inside the home.
around the house. And David also watches the other two kids, which both have autism. And every time he's out of the house, the kids revert back. This allegation came out in 2022. The investigator said that she recanted back then, but I'm going to go ahead and turn it over to the DA for review. And they didn't file until 2025. So I'm hearing all these stories, and I've met Phoenix, and it is a complex case. She has multiple personalities. She talks to multiple individuals. I've had ad length conversations with her. She's the sweetest thing that has been tormented, but it is so wrong to be wrongfully accused on an allegation of this severity.
All right, so this is what I can tell parties I want. If somebody will pick up the phone, call the CPS worker, and was there a child's ad litem involved in this or no?
Not that I saw, Your Honor, throughout the CPS records.
Any attorneys? It's an attorney for the children.
They offered one,
Mhm.
and it never went through for some reason.
All right, so someone can have, because here's my thing, I will listen to your testimony and I always keep an open mind, but it appears that she's going to say she doesn't want the no contact order, am I right?
Yes, sir.
So I would like to hear from the caseworker. They're supposed to be objective. And I want to hear from them rather than just reading words on a page, because sometimes I have questions. So do y'all want to see if you all can call the caseworker? I'm sure they would zoom in.
State.
And then if you want to continue with your questioning of her, I'll listen.
I believe the judge kind of cut to the chase.
Yes,
You want David at home.
yes,
Do you need David at home?
we do need David at home.
Do
I'm
the-
a full-time nurse. I work sometimes up to 16 hours a day, 6 days a week. And either, his parents are also in the home, the grandma, they're also in the home, but they're 83 and 85. And they cannot physically handle the two youngest girls because sometimes whenever their mentation strikes, it gets completely out of control. David handles them, sits them down in the living room, turns on a movie in the living room, kind of keeps them all pretty much stable. Phoenix comes down, she sits in the living room on the couch on the end and watches TV with them. It's a family interaction. I can see everything they do in the house.
Let me ask you this, has David ever alone with Phoenix?
Never alone with Phoenix.
Are there cameras that there are boundaries in the house?
There are boundaries in the house. If David is downstairs by himself, Phoenix does not come down because of the interaction whenever Phoenix had it first. And then David being accused, we don't want that accusation to be able to be brought back up.
And lastly, has Phoenix made an allegation where it is clear that David is out of the house and it could not have happened?
There have been a couple of times whenever David wasn't even in the house, he was at work, or he was busy with the church, working on beds and stuff, where she said that he's done something and my son's been present in the house and has told her that didn't happen. He was in the backyard working on a playground for the younger two, And she accused David of something that he didn't do because she'd never been outside and David was only outside and she accused him at the time he was working on the playground himself. Joseph was on the back porch watching. And she blatantly made an accusation against David that didn't happen.
In your opinion, do you think the children are safer with David in the house than David being out of the house?
Yes, I do. I think that they have developed such a relationship that taking David out of the house, the youngest one actually reverted back to peeing on herself and peeing in the bed and unable to focus at school.
And how old is she?
She's 9, pigmentation about a 3 to 5-year-old child.
All right.
Other questions?
Any questions, Dave?
Yes, so when David was arrested for this back in 2024, was that when that
Yes,
out of county?
yes,
And since that time, actually, since 2023, he's been in the home with you in Phoenix,
yes,
even after these allegations came out.
yes, because the courts cleared him. Or not the courts, but yes,
Right.
All right, so I have a couple of questions. Are there any objections?
Not really straight.
None from defense, Your Honor.
All right, so you say there are cameras in the house. Where are the cameras?
There are 3 just down the hallway for the girls.
Mhm.
There's one in the corner above the bathroom that looks at the youngest children's door
Mhm.
because Mia sometimes has the tendency to come out of her bedroom and fall down the stairs.
Okay.
So there's a camera there and it triggers whenever somebody exits their bedroom. There is a camera in the corner of the hallway looking exactly this way down the hallway where the gate is, down the hallway here where the girls' room is, and on Phoenix's door with the back.
So, correct me if I'm wrong.
Uh-huh.
So the only places there are no cameras are inside the bathrooms,
There are no cameras in the bathrooms.
but do cameras show anyone who's going into the bathroom?
Yes. And there are SD chips in each camera, so we can record and document anything that may come out as an accusation. There is also, because Phoenix was suicidal at one point, she doesn't have a door on her bedroom because we had to watch her closely. For 2 weeks, she was on suicide watch before she went into the institution.
Mhm.
And so there's a camera directly on that bed alone. She has privacy everywhere else.
So how many children in the household that are underage? And those are the 3 children that you took into your home?
Yes.
All right, and how many adults are in the household?
Uh,
All right, and who are the 5 adults?
my son, he's 30 years old. He is upstairs with the girls when they come out of the gate. His bedroom's right there.
Okay,
My father-in-law sleeps on the other end where the children's playroom and TV room is.
okay,
And David's mother, who is downstairs at the very front of the house,
okay.
and then me and David.
All right, any other questions?
Yes, Ms. King, the 2 younger children, they're nonverbal, is that correct?
Oh, no, they're not normal. They're very verbal. They're very high functioning.
I functioning.
Yes.
No further questions.
Yes.
Just for clarification, Phoenix did go into inpatient care for how long?
She was in for 7 months this last time at Cedar Crest Hospital.
Okay, and so if she gave any indication whether this did or didn't happen to them as
Yes.
well, you weren't around.
I
they
wasn't
could talk
there.
there. And lastly, the state says that David was arrested on in 2024. It was actually March 19th of 2025. Is that correct?
That's right.
That's all, just for.
All right,
That was the other place.
and other than this child, have any of the other children accused him?
Accused him? No, Your Honor.
They
But
accused her
they are verbal and they accused Phoenix of
while she
acting
was
out.
institutionalized.
Okay,
And she knows that she did it. She will tell you.
okay. All right, so if y'all can have this, the caseworker zoom in, the court will make its ruling.
Thank you, Your Honor, very much for your consideration.
Sure, you're welcome. And if you talk to Norma, once you have the number, she'll give you the Zoom link.
Morning.
So as you can see,
have a situation.
So very complicated. And the decisions you make as a judge, you're hoping they're the right decisions. Because you don't have a crystal ball that can say, oh, you know, this person committed this offense, because everyone is presumed to be innocent. So it takes a lot.
Here.
Oh, yes, they're supposed to keep their records, so she should have records. All right. Jeffrey Patrick Smith, good morning. So you're saying, I don't know, is this a motion for a new trial?
No.
I don't know why this is on the docket as a motion for a new
You
trial.
asked us to come back and get a trial setting. Our
Yes.
first trial setting was last week. I did a motion
Mhm.
for continuance. You granted us. You wanted us here today to set a date.
Okay, this is just on the, oh, you know what the problem is? They did not, it didn't come out on the docket correctly, so it's to obtain a new trial date.
Yes.
All
Yes,
right. Have you conferred with the state?
we have, Judge.
And have you all come to an agreement on a date?
We have. We actually have two dates.
All right, what are the two dates?
October 20th and November 3rd.
October 20th,
And November 3rd.
November 3rd, my birth month.
Very good.
So,
Well, there you have it. November 3rd, maybe?
okay, I'm sure I will be in an excellent mood to be at work during my birth month. So, which do y'all prefer?
November 3rd. So,
Okay,
see,
so they're assuming I'm gonna be in a great mood. It's not gonna be, oh my gosh, father time is catching up to me.
Judge, is that a family violence case?
No, it's a.
Criminal trial division.
Family, violence case.
All right, so what's the other date?
I don't know, they didn't
October
confirm.
20th.
Oh,
October 20th. I don't know, what is October 20th?
I can't do October 20th.
Cannot
Okay.
do October 20th.
all right, so criminal trial division,
Would,
if you all confer with Ms. Ferguson on a jury trial date for this case, how long do y'all expect this trial to last?
3 to 4 days? This is a couple days, Judge. I mean, that's not put a word out here, of course, but.
All right, so 2 to 3 days.
I can do November 12th. November 4th.
November 12th? Okay.
Yeah.
So in this court, there are certain weeks that it's family violence week, certain weeks that it's criminal trial division. That can give them a rest instead of being in trial back to back to back to back.
No, November 12th is a Wednesday. Am I wrong? Because November 11th is holiday.
Well, Norma, then,
Okay.
you say the holiday is the 11th?
Yes, it is, Judge.
So can you put it on November 10th then for jury selection? Will we have jurors? Or is that not a good idea?
I can ask, I think we do, because I haven't got it, usually I'll put it on my calendar.
Yep.
But do you have quick floater cases on Monday? To start on Monday.
For a trial, so for jury selection? Well, then, if you all want, you won't be number one, but we can put you on the 10th, see where you fall.
Okay, fair enough.
And if it doesn't go,
Yeah, but I.
it doesn't go. It's just that older cases go first.
We'll make the state bring birthday cupcakes, Judge.
No, because I'm on a diet. I'm
We're all on diets forever.
No, you look fine. And thank you for dressing appropriately for court. So you will be back on November 10th. And then if all goes well, we'll do jury selection on the 10th. And I'll ask the jury to come back on the 12th. And we'll start with trial on the 12th.
Sounds great.
Because if we were to do jury selection on the 12th,
Okay.
then that's going to be a very long day for somebody because we'll do jury selection in the morning, testimony in the afternoon, and then we may not finish.
Right.
All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
All right, thank you. You too.
We'll have a seat, sir. He'll take it to you.
And counsel, I have your acknowledgement of discovery, correct?
We did plea deadline in, I want to say July, Judge. I'm pretty sure we did.
Yes, I have it. All right, thank you.
Thank
So what ends up happening, normally depending on the type of case, if it's a second degree or first degree, I'll let all attorneys confer on what would be a good jury trial date for them. And that way we'll come back on the date that they pick Now, sometimes what will end up happening is they'll pick a date and then they come back wanting a motion for continuance, and I'm like, this is the date you picked, so, yeah.
Okay.
Mr. Benjamin,
Can you hear me now?
so I can hear you now, although I don't see your video.
Oh, can you see me?
There you are. Hello, how are you doing, sir?
Good morning. Good. How are you?
Oh, I'm doing great.
Yes, ma'am.
So what is going to end up happening is your attorney is actually on vacation. And I always tell people everybody needs a vacation once in a blue moon, right?
Yes, ma'am.
You know, the job wears you down.
Mhm.
You're not thinking clearly. So
Mhm.
hopefully he's enjoying vacation.
Right.
What we'll do is we'll bring you back, and we'll bring you back by Zoom again so that
Okay.
you all can get your jury trial date, okay?
Okay. Yes, ma'am.
All right. And what is your work schedule?
I'm usually only off on Tuesdays.
All right. So what we can do is we'll recall this back for a Tuesday.
Okay. Thank you.
Norma, when is he back from vacation?
Not until the 28th of this month,
All right. So can you set this in September on a Tuesday, please?
September 9th.
All right. So we'll come back on September 9th
Okay.
and you can appear by Zoom.
Okay. I appreciate that. Is it going to be the same Zoom ID?
Yes, it will.
Okay. Thank you.
And thank you so much for dressing appropriately for court. I really appreciate that.
All right. Thank you.
All right. Have a great rest of your day.
All right. You as well.
Have him set for September 2nd.
Right. And as far, I have not received a report yet,
Mhm.
and, but it doesn't surprise me if he's unstable.
All right. So do you want him by Zoom or you just want to get it reset?
I would say reset it, Judge.
All right.
And I'll check with Judge Rodriguez's court and see if they know anything about it.
All right, Norma,
Yes, ma'am.
if you can put this, I can put it for the second weekend. Bring it back then, or either I can just put it that way. I could put it on a different date.
I'm out of town the 16th. And I'm in Maine in October, but other than that, I'm around.
Well, do you want to bring it back on the 8th just to see what the results are?
That's fine.
All right, Norma,
Yes, ma'am.
on Holmes, can you recall it for September 8th? And Deputy Laura, he doesn't need to appear by Zoom.
Just go ahead and cancel them off because I.
Yes, yes.
So they didn't bring him over from the jail.
Well, they couldn't bring him over.
All right.
So, but if you want him here, we'll have him. Okay. All right, we'll bring him back then on September 8th.
Okay, thank you.
All right, thank you. So we're going paperless. Here's the thing about that. That's good and that's bad because nobody can tell me if this system crashes, what happens. And this system did crash for about 2 hours. Everybody was lost because we don't have any paper. Everything is on the system. So we shall see. All right, John Castro Lopez. Oh, you're back. It was just,
Morning, Judge.
were you not just here?
You can't get rid of me.
Thank you. All right, so where are we with regards to offers being, well, an offer was extended.
Yeah, and Judge, there's been a new offer extended. I will tell the court I am going to re-indict the case. Yeah, based on some case law research that I've done. And then also defense and I are continuing to get together so we can review discovery. There's a cell right that was done in this case. So that we'll continue to work on that to kind of make sure that we are all lined up in terms of what the work business space.
So my understanding from talking to Mr. Spear is that there's still an issue as to what level felony this is. Probably not a first degree, but it's based to some degree on the number of images that they're alleging, and they're still determining that. And I have yet to see the images. I've seen 3 images, and they're saying there may be 100 or less or more than 100.
So when are you gonna have the rest of the images for him if there are other images.
Yes, Judge, I don't anticipate that will be in trial this week, so my hope is that I'll have that answer this week.
All right, Ms. Ferguson,
Yes, ma'am.
recall this for the week of September 8th.
Yes, ma'am. I can do the 9th.
All right, so you all will be back on September 9th. All right, David Guerra.
Good morning.
All right, good morning. Just one moment. Criminal Trial Division, could you confer with Ms. Conley? It's an off docket matter, but it's for a motion for continuance. Yes. So where are we? Was an offer tendered?
We've been given an offer, Judge, and we'd like to have a plea deadline for my client to consider it or if not.
All right, sir, how old are you?
66.
All right, is this Criminal Trial Division or Family Violence?
No problem.
All right, Ms. Ferguson, can you set this for the third week in September for a plea deadline date, please?
Sorry.
I can do, September 15th.
All right, September 15th. Once you sign the reset form, you're excused. And thank you for dressing appropriately for court.
Thank you.
And counsel, can you make sure you have an acknowledgement of discovery completed before you leave?
Yes.
Thank you.
And it's definitely David Gavin.
Yes, on page 8.
He also has the violation report that was filed.
All right, could I get a copy of the violation report?
David Gavin.
Did you not report to your pre-trial?
That's second.
That's it.
All right, so you're here for a missed appointment. So this is what I want to explain to you. This is your first violation. State Criminal Trial Division.
Yes, Judge.
All right, we have it's his first violation report from pretrial services. It's for a missed appointment. Do you have any objections to continuing him?
Not at this point, Judge.
All right, all right, thank you, Mr. Garrett. Here's the thing. You have to appoint to court because you get a reset form on when to come to court. But you also have to report to your pretrial services officer. Your pretrial service officer is somebody completely different than court. And so when they give you a date and a time, you have to make sure that you're there on that date and time.
When I get out.
Well, no, that's for
That was
today.
time.
But this is a previous misreporting, so do not misreporting, all right?
Okay.
And so when you leave here, you need to call them
Yes.
today and let them know that you were in court. You understand?
Yes.
You have any questions about what they're asking of you?
No, that's.
Do you understand what they're asking of you? Is there any problem with your reporting to them?
No.
All right, so make sure that you report to your pretrial services officer and it's Demas, okay?
Yes.
And counsel, do you need the number for them as well?
No, Judge, I have it.
All right,
I think I have it.
all right, thank you.
Yes.
All right, Fernando Guzman.
Good morning, Your Honor.
Good morning, how are you doing today?
We set for Wednesday, Your Honor, but I just got hired over the weekend. It's on this computer. I do file.
Okay, I can't believe he's set on a Wednesday in here. All right, okay,
He had a surgery, but his lawyer didn't show up for the full last time he was here, so they reset it. But I haven't seen anything yet.
okay.
I just want to wait. Just till next week. I can give it.
All right, so I have to read the motion for continuance. So let me read the motion for continuance and then, all right. All right, Norma, set this for the week of September 8th, please. All right, you'll come back on September 8th.
September
Base.
8th,
8th.
yes, you're welcome.
This is Monday. That's perfect. Thank you. Do we need to sign anything, Norma? No. Thank you. You're very
Welcome. Have a good one.
Thank you. Yeah, yeah.
All right, Brianna, Lorraine, Luna.
Can we push her?
Yes. Good morning. Hi, thank you for dressing appropriately for court. I appreciate that. All right, so where are we on discovery?
Judge, we're still missing discovery. We're missing 3 dash cams specifically.
Okay.
I can list those if you prefer.
All right, dash cams and what else?
That's it at this point, Your Honor.
All right, so do you know where the dash cams are?
I would assume it's as easy as requesting it from the detective and it should be in evidence about one, so about a week or so.
Okay. And so that's the only thing?
Yes, Judge.
All right, Ms. Ferguson, I need a reset for 1 month, please.
Yes, ma'am. Give me 1 second. I'm sorry. I can do this was September 30th.
All right, so on September 30th, state an offer. You'll need to be prepared to tender an offer. And then your next court date is going to be a plea deadline date. Do you understand?
Yes.
All right, so plea deadline date, what it is the next date for you all to reach an agreement. If you can come to an agreement, if you can't come to an agreement after that date, then your next date is either going to be a jury trial date or a bench trial date. And your attorney will explain that to you. All right, do you have any questions about anything?
No.
All right, just have a seat. Your attorney will bring your reset form, and once you sign that, you're excused. You're welcome. Thank you.
May I be excused at that point too, Judge?
Yes.
Thank you, Judge.
All right, so a lot of these cases, they've just been indicted and this is their first appearance ever. So usually nothing happens on their first appearance because attorneys need to talk to them. And I just have to make sure that they have all of their discovery. All right, Noah Alvera. Thank you for dressing appropriately for court. So here's the thing, you were late today. Why were you late? All right, so let me explain something to you. Number one, this is your first time in this court, right? So now you know where the court is located. You know about traffic because there are school zones. You need to make sure you're on time. You understand? So 9 o'clock. Do you understand? Yes.
Yeah.
Right. So where are we on discovery?
Judge, she's creating a discovery acknowledgement. We're prepared to sign that. He just got an offer today. If you would like, if we could get a plea deadline setting, I think we'll resolve the case at that next
All
setting.
right. So how old are you? 20? All right, Ms. Ferguson, give me a 30-day reset for a plea deadline date. Counsel, if you want him back sooner than that, you can bring him back sooner.
Thank you, Judge.
September 30th.
Okay.
All right, so on September 30th, that is the date where you come back and you'll let me know whether you've reached an agreement with the state or not. If you all have not reached an agreement, your next court date is either going to be a jury trial date or a bench trial. And your attorney can explain to you what those differences are. You understand?
Yes, ma'am.
All right, just have a seat. Once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome. And counsel, you all have the acknowledgement and discovery signed before you leave?
I will, Judge, yes.
Okay. All right. Veronica Callahan?
I just wanted to approach the court.
All right. So is a warrant already out for her arrest or no?
I'm sorry, Bridget.
It's Veronica Callahan on page 6. All right, Deputy Laura, could one of you make an announcement for her in the hallway?
Just so that I can let the court know. She said she was going to the doctor this morning. I haven't received anything, but I will reapproach when I do.
All right, court is calling 2025 CR 008561 State versus Veronica Ann Callahan. Can I have parties announced for the record for the state?
Lauren Espinoza for the state.
The defense?
Matthew Allen for Miss Callahan.
All right, this hearing was scheduled at 9 a.m. It is now 10:18 a.m. The defendant has not made an appearance in the courtroom. Deputy, did you make an announcement for Veronica Ann Callahan?
I did.
And the response?
Negative contact.
All right, defense, have you had contact with your client?
Yes, Your Honor. She notified me this morning that she was going to the doctor. I let her know that I needed a note so I could provide that to the court. I haven't received the note, but she has said that she would let me know. So, but that's the update as of now, Judge.
All right, state request.
We'd ask for a bench warrant.
All right, the court will issue a judge's warrant, remand her without bond. If she makes an appearance and provides proof, the court will reconsider.
All right, thank you, Judge.
Great, thank you. All right, John Anthony Cruz. So where are we on discovery?
This is a first setting, but I am signing the discovery acknowledgement. There's not a lot of discovery. They did tender an offer today, Judge, but I had scheduled a jail visit to be able to discuss things with my client.
last week and there was a mix up at the jail. So I just want to have a reset to be able to discuss with him his options because we
Okay.
really didn't get a chance.
All right, Ms. Ferguson,
Yes, sir.
can I have a plea deadline date for 30 days, please?
Just September 30th.
That'll work.
All right, if you want him brought over sooner, just let the court know.
I will. Thank you, Judge.
All right, thank you.
No.
Victor Mamuth?
He's not here, Judge.
All right, and where's your client? Is he a future? He already has a warrant?
Yeah, Judge, he's not here for the
Okay.
point. I've had no contact with him, so I don't know what.
All right. Thank you. Well, do you have all the discovery from the state?
Sure do, Judge.
Okay. And was the state able to tender you an offer or no?
No, not today, but I'm a fine present.
Right, so if you can get an offer for them and then you're excused.
Okay.
Thank you. Thank you for dressing appropriately for court. I appreciate that. All right. So where are we on the discovery with the phone calls?
Phone calls, Judge, in terms of ACS, we have requested that they give us information of that, so it is still pending. We were able to get a report from ACS to the state for their file in terms of some background regarding a previous complaint regarding a neighbor, Judge.
Okay.
One further discovery matter, and looking to the discovery further, downloading the videos, Judge. There are about 9 MP4 files that are too large to download through the typical e-file system, e-discovery system. So I have requested to get those manually from the prosecutor and have given them my disk drive. So I should be getting those today, Your Honor, and we'll just be requesting time to review those large files. There are body worn cameras associated with the offense from the force officer.
All right. Ms. Ferguson,
Yes, ma'am.
give me a 30-day reset for final discovery, please.
Yes, ma'am. I can do September. We'll do that September 30th.
All right, so on September 30th, it's to make sure that your attorney has all the discovery, and on that date states you'll need to be prepared to tender an offer. All right, is there anything else?
Nothing further, Your Honor.
All right, do you have any questions about anything? All right, so once you sign the reset form, you are excused. Just have a seat and your attorney will bring it to you.
Sure.
All right, Mr. Dreamer. So why were you late?
I was late because I was trying to get into the parking garage, Judge. There was a little bit more time than usual.
All right, so here's the thing. Court, you got to be here at 9, you understand? All right. You have been recovering from a lot, Mr. Bauer.
Yeah,
I'm like, it's like one thing after the other.
yeah, 3 weeks ago I was sick and I was sick last week, so I'm feeling somewhat better, but
I mean, you say somewhat better. Do we need to mask you?
no, I actually
Okay.
tested negative twice
Okay.
in the same day, so I don't know what's going on, but just old age, I guess. There is a unindicted pending felony that I think is kind of the bigger case that we're waiting on. That's handled by the PIC unit. That I think the intent is to try that, what I think would resolve everything, but I think we're waiting for a response from PIC.
All right, and what case is this?
It is a sexual assault as well as an invasive visual recording
Okay, so when do
picked up from us and they're intended to.
you know when they will have something?
I just emailed them when Mr. Ma first approached me. They haven't responded back again, but it's been few settings.
All right, so this is what I'm gonna do. I'm gonna give you all a reset for the final setting in regard to that. But on this date, you'll need to come back with a, well, actually, you need a jury trial date on this one. So you're gonna get a jury trial date on this one. And if they're not ready on that case, then they're not ready on that case, but this will go.
Okay,
So how long do you expect the trial to last?
I'd say maybe 2 days.
All right, Ms. Ferguson, I need a jury trial date for family violence. They say 2 to 3 days.
Give me 1 second, Judge. October 21st.
All right, counsel, does that work for you?
Yes, it does.
All right, so your jury trial date on this case is going to be October 21st. Once you sign the reset form, you're excused. And thank you for dressing appropriately for court. I really do appreciate that. Just have a seat and your attorney will bring the reset form to you. Bashan, we have a plea and it's an application. All right, who are the parties on Samuel Badillo, please? Court is calling 2025 CR 0086679 State versus Samuel Joe Badillo Jr. Can I have parties announced?
Melissa Christian for the defendant.
And are you Mr. Badillo?
Yes, ma'am.
Counsel, have you received all discovery?
I have,
Did you review with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Badillo, did you review the document,
Yes, sir.
the application for deferred adjudication?
Yes, sir.
Did you review it with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Are you proceeding with the
I'm
enhancement?
sorry. We moved to waive the enhancement and proceed as count one.
Any objection?
No objections, Judge.
All right. Did you review the court admonishments with your attorney?
Yes, sir.
Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand your charge with possession of a controlled substance penalty group 2? 1 to 4 grams, that's a 3rd-degree felony.
Yes, sir.
Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
We've discussed that, Judge, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Badillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea? I'm sorry?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, sir.
All right. So the district attorney's office has changed the paperwork. So I will not be asking you whether or not you're a citizen, but I'm going to give you these instructions or this knowledge and just internalize it, okay?
Yes, sir.
If you're not a citizen, you could possibly be deported, not allowed re-entry into the United States, and denied naturalization. Do you understand?
Yes, sir.
All right. The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, sir.
Defense?
Yes.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. Proof of employment that you obtain your GED and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offense as charged, how do you plea?
No contest.
State any evidence.
Yes, Your Honor. State offers what has been marked as State's Exhibit 1 in all practical.
We have no objections.
All right, state, you may be excused. Thank you. Did you review the waiver and stipulations with your attorney?
Yes, sir.
Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, Mr. Badillo is very young. He's 22 years old. He's not employed at the moment, but he has independently been working on his GED. He got as far as 9th grade. He is not married. He does not have any children. He and I discussed the benefits of deferred adjudication, and we also discussed how important it is for him to immediately pounce on doing those 200 hours of community service and any classes or anything that the probation department might recommend. He is very interested in getting his GED and moving on with his life.
All right. So why have you not graduated high school? What happened?
I had dropped out.
Why?
I had family issues.
What type of family issues?
Got kicked out.
Why? I mean, there's a reason. I mean, if you have loving parents, they just don't, you don't just come home one day and they kick you out.
I mean, it's just like mother instead that, my mother chose her boyfriend over the son. So
All right. So, but why did she agree to kick you out?
she just did, I'm not, honestly, I don't know.
So do you have any siblings
Yes, ma'am.
and brothers, sisters?
Yes, ma'am.
Well, do you have brothers or sisters or both?
Both 2 sisters, 1 brother.
All right. And how old are your sisters?
17 and 12.
And your brother?
10.
All right. So do they have any problems with so just you?
My mother's no longer with my stepdad.
So who's your family support?
Yeah.
All right, just one moment. I'm sorry. Sorry, that's concerning another matter, another case that we've been waiting on.
Thank you.
You're welcome. All right. So who's your support system?
My aunt.
All right. And will your aunt allow you to live with her?
Yes, ma'am.
And then the next thing is, what type of warrant did you have? Because I read in the police report that there was another warrant that was outstanding. What was that about?
Parole warrant.
Parole warrant? Is that from youth? He was a juvenile?
Is that a TYC warrant?
Yes, sir.
Okay, it's an adult warrant from Bear County?
And you're saying a parole warrant?
I don't think that's right.
No, I don't either. I mean, did you go to prison?
Yes, ma'am.
Okay, what did you go to prison for?
Family violence.
All right, and was it prison or was it jail?
Prison.
How much time did you do in prison on that case?
Did a year. They gave me a 4-year sentence.
Oh, they gave you a 4-year sentence and you did a year on it? All right. And are you still on parole?
Yes, ma'am.
And have you had a parole hearing yet?
They told me I wasn't gonna have a hearing until after this case was dealt with.
Okay. So counsel, do you want to go forward with this, knowing that he's on parole? Or do you want to discuss with him what potentially could happen?
We had discussed it previously, and this is now ringing a bell with me that we had discussed this previously, but that was a situation, Judge, that case, he probably never should have taken a plea to prison in that case. And the parole board, the fact that the parole board was willing to wait to see what was going to happen here indicated to me that this is probably the best course just to go forward with the deferred.
So do you know who the complainant is in that case? Because then I want you to make sure that you don't have contact with that complainant.
Who was the complainant, Mr. Bailey?
My uncle and my mother.
All right, your uncle and your mother. And the aunt that you're staying with, she's not married. You know, I know sometimes people will call their aunt's husband their uncle. So this uncle is not married to the aunt, is it?
No.
All righty. Complicated
Very
family.
complicated, unfortunately.
All right, so what were you doing using drugs?
I was having a little mental issues out there,
What type of issues?
like depression, anxiety, and really that's really the only thing that I could think about going to was drugs.
All right, so this is what I can tell you. One, I'm going to try to give you conditions that can solve all these issues or at least put you on the right path. But I've done parole hearings in the past. Sometimes they wait to see what's happening on this case because then it makes it easier for them, right? And when I say easier for them, you enter a plea on this, whether it's deferred or not. They look at it as conviction, right? But I'm going to grant your application. We're going to try to get you some help. What I can tell you is people say probation in this court is not easy. I see people as human beings. Hopefully this probation will get you on the right track. And whether it gets you on the right track or not, 100% dependent upon you. But if for some reason your parole ends up being revoked, your attorney can come back and we'll see what we can do about this. Do you understand?
Yes, Your Honor.
So knowing that parole could still revoke you if you accept this plea, do you wish to go forward with the plea?
Yes, Your Honor.
All right. All right, this is what the court is going to do. The court is going to sentence you to $1,000 fine. That will be probated. 3 years deferred adjudication. Proof of employment 40 days after release. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. There's going to be 200 hours of community service restitution. 100 of those hours will be deemed satisfied upon completion of a GED or some type of trade school certification. And since I know that you just went to prison for the family violence, the remaining 100 hours will be deemed satisfied once you complete an anger management course. There's going to be field visits 1 time per month until further notice. And I'm going to do a referral to felony drug court. That's going to be in custody. That will take care of, they have dual diagnosis. So if you have mental health issues, they'll be able to address that. Drug issues, they'll be able to address that. But you have to be honest with them. And what I can tell you, if you're in the felony drug court program, if you get accepted, that will be something that could help you with your parole. Okay, so that referral will be done in custody. They should be able to have us an answer back this week since it's Monday. Out of custody, we can do the TAP evaluation and mental and MIC. Probation, is there anything else?
Are you making anger management one of the conditions, Judge?
Yes.
I'd not the other.
All right, is there anything else you need from the court in order to be successful?
Yes, ma'am. And no, there's something else.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're young and you've been to prison. And I know there are certain things that happen in prison and it's not a great place to be. But this is your chance to get your life on track. Please do not go out and start having children because you're not ready to have children at this stage because you have the parole matter, you have this. And so your life is a little bit in flux. You don't have a job, you don't have your education yet. So before you even think about having a child, get this under your belt, get parole under your belt. You understand?
Yes, Your Honor.
All right. In this court, communication is key. If there's an issue, don't just disappear. Let probation, you know you're having an issue. If they're not responding to you, you can come back to court. And counsel, if he ends up being revoked, you can come back to court with this matter.
Okay, Judge, thank you.
All right. Thank you. All right. So yes.
She did inform us that unfortunately, both the worker and the supervisor are both no longer with
With
CPS anymore, and she will not have any other further information she could give us.
All righty. Well, let's go back on the record. Court is recalling 2025 CR 01961 State versus David Lopez. And I will hear your argument. I'm assuming there are no further witnesses.
That's correct, ma'am.
All right. And Cindy, for the record, the state has informed the court that the caseworker on the CPS case and the supervisor are no longer employed with CPS. All right. I'll hear argument.
Yes, Your Honor. So the reason the state is asking for the no contact order, one, because of cases like this, these are bond conditions that are typically put in place. That was not put in place. The defendant was arrested out of county and then bonded out. So whoever magistrated him out of county did not put any conditions on. My understanding is that from reviewing the CPS records, yes, CPS did allow the defendant back in the home after these allegations came out, and also after they found reason to believe. And to me, that just does not seem reasonable. And so that is why the state is asking for the no contact order, because the child has been in the home with the defendant and with her mom, for all intents and purposes, who she's been in the home this entire time with the defendant who she says has abused her, and the state cannot adequately analyze their case while the child is still in the home with the defendant.
All right.
Your Honor, if I may please the court. This case, the allegation happened in 2022. The officer did state that he had gathered all the information as he saw fit, but was going to turn it over to the DA, even though the alleged complainant recanted. This case wasn't picked up until March 2025, where CPS had already allowed my client back in the home, and there has been no indication of anything going on since 2023. It has been status quo. He also bonded out on a $100,000 bond from the state's investigation, or from their investigator, which kind of charged him incorrectly. I believe his bond is overly intrusive. I would hate for his bond to be reduced and him to have to rebond out to go through the process, because he's already spent everything he had on the $100,000 bond. They have adequate cameras put in place. Everything has been status quo since. You've heard a very small portion of why the children need supervision at home. Also, David's supervision at home. He has cameras in all the right places that need be. There are other individuals in the house as well. And I just think it would be overburdensome for my client to have additional conditions that weren't put on until August of 2025, when the state is finally getting ready for this case. We've been ready, well, since March. I'm asking that the bonds remain in effect the way they are until trial, and we'll be ready.
All right. So this is what the court will note for the record. The indictment, and both parties have agreed that the indictment is incorrect, that he does not have a prior conviction. Is that correct?
Yes, Your Honor.
And then the court will note that he's been in the household for this length of time. Both parties have agreed that the witness has recanted. Here's my question for you, because I still, CPS does their investigation. Their investigation is their investigation. I know that you've been in the house for the length of time that you've been in the house. I know that you have cameras up. Question for the court is, will you make those cameras accessible to the DA?
Most definitely, Your Honor.
All right. So if he's going to make sure that the cameras are accessible to you, my understanding, it's an SD card in all of the cameras.
Yes.
All right. How often are you going to want to view the SD card?
Your Honor, I guess it's something I can work out with.
All right. If y'all discuss that, but I'm not going to order the no contact order based upon everything, the evidence that the court has heard based upon the indictment being incorrect. If the indictment were correct, this would be easy for the court to make a decision on.
May I ask my client one question?
Sure.
Off the record. Your Honor, it's my understanding that these SD cards record for 30 days. I would say.
Do they ever,
I was going to
is
say,
there any
can we get
recording over?
No, I was going to say, can we get a double and have them available for the state every?
If you all will discuss that,
Okay.
how often you want those available, but I'm not going to grant the request for the no contact order based upon the evidence that I'm hearing. But I am going to add the condition that the state is allowed to view the SD cards. And if you all can just come back to me and you all can write it in the order, how often you want those SD cards to be reviewed by you. All right. So will they be able to turn over the SD cards?
I will have my client buy additional SD cards and then provide them to me, and I will have them available for the state. And then I guess when we give them the next ones, they'll give us those back.
All right, so we're at the end of the month now, so I'm gonna want an SD card provided to them before this month is out. And then after today, let me see. So that will, when will you be able to provide that to them? Friday?
Your Honor, I'm stepping into something I don't know. What I'm wondering is if I could provide like a 2 terabyte card and all these SD cards be loaded. That way the same cards can be used and I can constantly have these.
Sure, but my understanding though is, are you gonna be able to provide it to them at the end of this month?
I'll take care of that.
Yes,
All
sir.
right,
I will
so,
get more SD cards, and my outdoor cameras have a home base, so it has a 2 terabyte hard drive in it. If you have access to plugging it, I'll take the hard drive out and review it, and then I can put it back in.
all right, so we'll begin with the first date, the end of this week, and then 30 days thereafter.
Yes,
All right. Is there anything else?
not from the state judge.
Nothing from the French, Your Honor. Thank you
And
for
let
your
me see,
consideration.
does he already, yes, he's coming back. All right, if there's nothing else, then you will be excused. And thank you for addressing the appropriate court. I'll sign this order and then you will have it.
Thank you, Judge, very much for your
You're welcome.
consideration.
Thank you. Daniel Flores. Right, counsel, where are we on discovery?
So Judge, the complainant in this matter is in CPS custody and actually is hospitalized at this time.
Mhm.
So there's ongoing medical records that will need to be discovered. In addition, we are in the middle state, it's going to go forward in this matter. So we definitely need a reset.
Okay. All right, Ms. Ferguson,
Yes, ma'am.
give me a 45-day reset for discovery on this case, please.
Yes, October 9th.
That's fine, Judge.
All right. Do you have any questions, sir? All right, thank you.
Thank you, Judge.
You're welcome. Henry Rodriguez. So where are we on discovery?
We need to deliver a thumb drive for a number of telephone conversations, Your Honor, to the state.
And is that the only outstanding? Oh, come forward, sir. This is about you. All right.
That's it, Your Honor.
And that's the only discovery that's outstanding?
Yes, Your Honor. Sure.
All right, Ms. Ferguson, if I can have a 30-day reset for discovery, please.
September 30th.
All right, we're going to come back on September 30th and state you'll need to be prepared to tender an offer.
What's been tendered?
Oh, so Norma, September 30th is plea deadline day.
Yes, ma'am.
All right, thank you for addressing appropriate for court, sir. So when you come back on September 30th, you need to let me know whether or not you've reached an agreement with the state. If you have not, your next setting date will be a jury trial date. Do you understand? All right, once you sign the reset form, you're excused. Just have a seat. Your attorney will bring it to you.
Thank you, Your Honor.
Thank you. All right, on Troy Mishler, are you all going to be requesting a PSI? All right, I need a reset date for a PSI.
Yes, ma'am.
Oh, I think someone here can put the offer on the record. I'll walk them through it.
October 13th.
All right, Ms. Mishler, Mr. Mishler. Come forward, please. All right, could a prosecutor take this plea, please? And I'll walk you through the plea.
Sure.
Court is calling 2024 CR 010526-02. Can I have parties announced?
Carissa Chakowski for Mr. Mishler.
And are you Mr. Mishler?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mishler, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears from the indictment and the plea paperwork, you're proceeding on counts.
Just counts 1 and 10, Your Honor.
All right, thank you.
I apologize.
All right, if we can go off the record for a moment.
Your Honor, just for the record, my name's Andrea Crespo for the state.
I'll have the full indictment? Because this only has one count. Yes, ma'am. I'll go ahead and bring that right now. All right, so you're proceeding on counts 1 and 10?
Yes, Your Honor.
And how many counts?
There are 10 counts total, Your Honor,
All right.
and so we're proceeding on, yeah, one.
All right, any objection to the waiver of the other counts?
No, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, did you understand in counts 1 and counts 10, you're charged with possession of child pornography younger than 10 years of age and possession of child pornography less than 50 videos. And the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine, and anywhere from 15 years to 99 years or life imprisonment with a possible fine up to $10,000. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
You have, Your Honor.
The indictment being finished right now, Judge. Do you believe he has a rational as well as a factual understanding of the charges against him?
We do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
And counsel, you want to announce as well?
Sam Locke, with Ms. Chilkowski representing Troy Mishler.
Mr. Mishler, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I'm so sorry.
So this is State's Exhibit 2, Your Honor, with the motion to seal attached. So that was just defense's copy. So this
All right,
is-
thank you. All right, we can. Let me re-ask that question because the paperwork has been changed. Do you understand that if you were not a citizen, that based upon these charges and entering into a plea of any of these charges, you could be deported, not allowed re-entry into the United States, and denied naturalization? Did you understand?
Yes, ma'am.
All right. All right, everyone, if y'all could stop approaching, we're on the record, and I'm trying to focus on this. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on counts 1 and 10. They're asking that your punishment be assessed at a cap of 30 years in the prison. There's a $5,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? To count 1 in the indictment, how do you plea?
Guilty.
To count 10 in the indictment, how do you plea?
Guilty.
State, any evidence?
Yes, Your Honor. The state moves to admit State's Exhibits 1 and 2 into evidence. We've reviewed and have no objections, Your Honor.
All right, and with regards to the seal,
State's Exhibit 2, Your Honor, it does have a motion and an order to seal on that record regarding the content of.
all right, any objection to the court signing the motion to seal?
No, Your Honor.
All right, the court will find the motion to seal, which is a part of State's Exhibits 1, and it's listed as State's Exhibit number 2. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty of counts 1 and counts 10. This will be set for a PSI and TAP evaluation on October 13th. Is there anything else?
Nothing from defense, Your Honor.
All right, once you sign the reset form, you are excused after you speak with probation.
Thank you.
You're welcome.
Will be excused.
Yes. All right, Jesse Ramos. All right, so where are we on discovery in this case?
Done everything we need, Judge.
Okay, and was an offer tendered?
Yes, it was.
And sir, how old are you?
21.
All right, Ms. Ferguson, on this case, if I can have a 30-day reset for plea deadline date and state, if you could do an acknowledgement for discovery, please.
Yes. September 29th.
All right, we'll be back on September 29th. At that time, you need to let the court know whether or not you've reached an agreement with the state. If you have not, your next setting is going to be a jury trial setting. Do you understand?
Yes, ma'am.
All right, in this court, docket is not at 9 a.m. Why were you late?
I was caught in traffic.
I'm sorry, what?
I was caught in traffic.
So
Downstairs and coming up and all that.
here's the thing. You gotta remember, school is in session. So there are gonna be a lot of people on the road, but everybody is required to be in this court at 9 a.m. Do you understand?
Yes.
So do not be late again, all right? All right, just have a seat and your attorney will bring the reset form to you. All right, thank you. All right, Richard Campos.
Morning, Judge.
Good morning. How's it going?
It's going all right. It's going all right. Excited about the football season too.
Oh, hey. All right, so Mr. Campos, you've been in this court to know. You can't be late. Do you understand?
I wasn't later.
You won't be late again, Judge.
All right. So today is plea deadline date.
We have not reached an agreement. We'll request a jury trial setting, Judge.
All right. And is this criminal trial division or family violence?
CTD.
All right, Ms. Ferguson. Well, let me ask you, do you have the transcript from the co-defendant's trial?
No, Your Honor, we don't need one at this time.
All right. All right, let's go on the record. Court is calling 2024 CR 2339A, State versus Richard Campos. Can I have parties announced for the record for the state?
State.
Brian Oriel from Mr. Campos.
And are you Mr. Campos? Yes. All right, so defense, in this case, you say you have all the discovery?
Yes, Your Honor.
Right. And the co-defendant did have a trial, but you're saying you're not requesting transcripts and you do not need transcripts?
No, Your Honor, we were able to actually be able to view the testimony to see if we were going to need it or not. And at this time, we do not.
All right, so you understand, Mr. Campos, that this trial setting, if for some reason your attorney asks for the transcripts and they're not completed by the time the jury trial starts, then you're not going to have the transcripts. All right, Ms. Ferguson, need a jury trial date. How long do y'all expect this trial to last? I'm sorry, how long? 3 days, Ms. Ferguson.
I would agree with that, Judge.
I can do the September 8th.
All right, September 8th.
Okay, Judge.
All right, once you sign the reset form, you're excused.
Yes, ma'am.
Thank you. All right, Andrew Reyes. All right, so Norma,
Yes, ma'am.
since the attorney who's the Spanish speaker has been placed on the case, has he already talked to him?
No, not yet, Judge, because we're waiting for Valentino to step out.
All right, so if you'll let him go ahead and talk to him and then so that at least he can have conversations with him while I do this. All right, on this case.
That's what I put on the list. That's not what I got here.
All right, do you have all the discovery? I know there was an issue with cases being moved.
No, Your Honor, that I know, I've got the paperwork on my client. They uploaded paperwork on the co-defendant, but I have not seen any videos or anything of that nature that I would assume they're gonna be since there was searches of the houses.
All right, what videos?
Yes, Your Honor. See with the body worn camera that I asked to be submitted and the videos still haven't quite transferred over through Verical, but I will see that that is done.
All right, Ms. Ferguson, I need a 30-day reset for discovery.
September 29th.
All right, this will be the final discovery. So September 29th, we'll come back and make sure that your attorney has everything. Thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you are excused.
Are they short?
Tony Hernandez.
Thank you.
All right, Ms. Ferguson.
Yes, ma'am.
On Miguel Aguilar on page 8, can you give me a 2-week reset, please? That's the one who you said was being taken to the hospital. And then on Oscar Orozco Naranjo. All right, if you guys can come forward, please. All right, the court is going to call 2025 CR 008245 State versus Oscar Orozco Naranjo. Could I have defense announce?
Valentina Kogut on behalf of Oscar Orozco Naranjo.
All right, and we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, Mr. Naranjo, your attorney has filed a motion to withdraw. She believes that you would, it will be easier to communicate if you had someone who spoke Spanish. Is that correct, counsel?
Yes, sir.
All right, do you have any objection to this attorney withdrawing and an attorney be appointed to you who is bilingual?
No.
All right, then your motion to withdraw will be granted. Thank you so much. All right, and then counsel, if you can state your name for the record, please.
Abelardo Garza.
All right, and do you speak Spanish fluently?
Yes, Your Honor.
Right. And are you able to represent Mr. Oscar Orozco Naranjo?
Yes, Your Honor.
And Mr. Oscar Naranjo, do you have any objections to this attorney being appointed to represent you?
Yes. Yes.
All right, this is what I mean. And I'm just going to repeat it because maybe my question wasn't as great as it should be. The previous attorney who was appointed to you did not speak Spanish. This attorney speaks Spanish. So this attorney will be appointed to represent you. Do you understand?
Yes.
All right. Then you'll be representing him. And counsel, do you want a reset?
Yes, Your Honor. I'd like time to look at it. I discussed it with him and I need to look at the discovery and see what's going on.
All right, Ms. Ferguson, if I can have a 30-day reset on this, please. All right, you will be brought back on September 29th. And according to the record, your client does have a hold. All right, I'll call DL Ramirez. And counsel, in this case, are there any applications?
Yes, Your Honor.
Okay. All right, so is there an application for community supervision on this case or
Yes.
just deferred?
It's an application for probation, Your Honor. I think they're opposing deferred.
All right, so are they
Not
opposing?
applying for deferred, yeah.
All right, so on this case, are you all opposed to community supervision?
Yes, sir.
All right, so any objection to the court? Okay, I see how you did it. All right, the court is calling 2025 CR 008662 State versus Alcadio Ramirez. Can I have parties announced?
Abelardo Garza for the defendant.
All right, and the interpreter has previously been sworn in. But for the record, would you state your name?
Arlene Abrams, license number 2081.
All right, Mr. Ramirez, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
And counsel, do you speak Spanish fluently?
Yes, Your Honor.
And have you been able to communicate with your client in Spanish?
I have, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Ramirez, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Right, you're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, state? The state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Right.
And did you intend to give up those rights and enter into a plea in this case?
That's right, yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Right.
Did you understand if you're not a US citizen, by entering a plea in this case, you could be deported, not allowed re-entry into the United States, and denied naturalization? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 5 years in the prison. There's $1,000 fine. The state is opposed to your application for community supervision. Did you understand that to be the plea?
Okay.
No, did you understand that to be your plea bargain agreement?
Yes.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor, I have not.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, seat offer states exhibit 1 in all attachments.
No objections, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
All right, and state, you may be excused. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Ms. Ferguson, I need a date for PSI.
I can do
And
that.
I'm so sorry. How did he plead?
No contest.
Thank you. Yes.
October 13th.
All right, we're going to come back for October 13th for sentencing. I'll request a PSI and TAP evaluation. I'll base my decision on your application based upon any evidence that's presented to the court. John Barry. All right, so what are we here for? Is this for a motion?
This is a motion to revoke probation, Your Honor. My client does intend to plead true.
All right, could I have the motion to revoke probation on this case, please?
What is this?
It's John Barry on page 9.
What are we doing?
Yes.
I'm so sorry, Judge, I was not ready.
No problem.
I don't even know if they did a search.
Okay. Renee, did you do a certification on this?
Oh, Your Honor, you know what? My apologies.
All right.
We get to do that, one
That's what it
portion.
was, just we didn't have it ready because we didn't have the search.
Okay.
I do apologize, Your Honor.
Oh, hey, it happens. It's a Monday.
Manic Mondays, so they say.
I just sat on the back real quick, just to get everything okay.
All right, thank you.
Diana, can you give me that cause number for John Barry?
Yes, that's 2025 CR.
Okay.
01
Okay.
2861.
Thank you so much.
All right, court is calling 2024 CR 012861 State versus John Barry. Can I have parties announced?
Warrant as counsel for the state.
Renee Munoz on behalf of Mr. John Barry.
And are you Mr. Barry?
Yes, ma'am.
All right, did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same John Cowan Barry Jr. who was placed on community supervision in 2024 CR 012861 for the offense of evading arrest detention with a previous conviction on February 27, 2025 for a term of 4 years?
Yes.
All right, state.
Yes, Your Honor, state is proceeding on violated condition number 41, which states on or about the 29th day of July, 2025. In Bexar County, Texas, the defendant, John Cowan Barry Jr., did then and there fail to comply with the rules and regulations of the felony drug court in violation of condition 41.
How do you plead to that? True or not true? And state, are you waiving the other allegations?
No objection from the defense.
All right, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes,
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 2 years, as well as take into consideration clause number 2025 PF 29310.
Your Honor, we would just ask if we can just be heard in terms of the time of confinement with certain justifications related to substance use disorder.
All right, and the case that you're asking to be taken in consideration, what were the last 4 digits again?
29310.
And what is that offense?
That is possession of controlled substance, PG1.
All right. So are you in agreement with revocation?
Yes, Your Honor.
Okay. And then the court then will hear your argument with regards to sentencing.
Thank you, Your Honor. In terms of the punishment to be assessed by the court, we asked the court to take judicial notice on the court summary provided by probation that he did successfully complete lifetime recovery inpatient for the dates of March 14th, 2025 through June 30th, 2025, which he was issued a certificate of completion for that inpatient lifetime recovery. We do know, and we are aware that the court knows that he was subject to felony drug court conditions. He did suffer a relapse in which he self-admitted to felony drug court that he was using substances. So there's no dishonesty behind his issues, Judge. He did kind of fall off. He was at a sober living home, and then he did abscond from there upon relapsing. He did state reasons for doing so, where he was trying to get back to his family members that live in New Mexico. He did state that his grandmother is suffering from cancer, lung cancer. It's very serious, as well as mother that has diabetes. So there needs some help. We do believe that since Mr. Barry is not from here, San Antonio, he didn't have the proper support system. So that's why I think he's proceeding with this route, trying to resolve these issues to get back to his family to provide the support that they're needing, Judge. He hasn't been to state jail before, and this is my understanding is an evading arrest seconds underlying offense. So we asked the courts to weigh all those factors and announce the punishment. We were asking for less than the two. Judge, we'd be asking for 10 months in a state jail facility based upon his issues with substance use. The fact that he picked up a new case is this possession case, nothing violent, and doesn't have a violent history, Your Honor. For those aforementioned reasons, we're requesting less than the 2 years.
All right. So the court is aware that this is a evading with on foot. It's not in a vehicle. But also the court is noting that you absconded. That's a problem. And with felony drug court, I know that if you tell them what your issues are, they would have made arrangements with regards to any health issues your relatives may be having. Court is going to grant the motion, sentence you to 18 months in the state jail facility, give you credit for any time served, taking consideration 2025 PF 29310, and the court will give you credit for any successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that means, you'll need to speak to an attorney. Do you understand? And I'll also request the therapeutic community. I have no authority to force them to place you in the program. I can't order that, but they'll see that it's in the judgment that you need help with any type of drug addictions. It does not increase the length of time that you're in custody. It's just to help you with your addictions.
Your Honor, would the court consider presumptively granting him diligent participation credit upon him doing substance use classes, vocational and educational training in the state jail facility?
I will consider that once I receive it.
Yes, Your Honor.
Right. All right. So here's the thing. When you're released from custody, if you truly want help with your drug or alcohol problem, if I'm still here when you get out, I'll help you find a sober living house. But at the end of the day, if you continue the path on that, you're on, only one of two things going to happen. Either you're going to end up in somebody's prison or jail for the rest of your life, or either somebody's going to be identifying your body because the last time you use may be the last time you use. You understand? All right. Good luck to you. So legally, I must give people credit for successful completion of inpatient treatment. So there's no way I can say, oh, I'm not going to give you credit for that. Now, sometimes there's a question over what successful completion means. I take a lot of things in consideration. The fact that he was arrested for a new charge, but then at the same point, it's a drug charge. So, and he's addicted to drugs. The fact that he absconded from felony drug court, which they're trying to help you. So it's a lot of factors to consider. All right, who did you say, Norma?
Marcus Butler, page 1, 7 down.
All right, Marcus Butler. Hello, Mr. Butler. Thank you for dressing appropriately for court. All right, so they have you, are you retained on this case?
No, Your Honor, I was appointed in April.
Yes, that's why they have that here. Norma, can you make sure that's corrected?
Yes, sir.
All right. So, were you able to open videos and all of that?
Yes, sir, and respectfully, I've gone over all the evidence with Mr. Butler. You know, I'm gonna call on the sword. One of the issues that when I was going through all the videos and everything else, there may be a legal issue. And I know this is a plea deadline date, but I'm asking the court if I had a little more time to look into that issue. Once I've done that, I think we'll make our decision.
All right, Ms. Ferguson.
Yes, sir.
On this case, I'm going to put your jury trial date the same date as your plea deadline date. If you want to come in before then, if y'all have reached an agreement, he can always put that on the docket before then. So how long do you expect this trial to last?
Maybe 2-3 days.
All right. So would he want a bench trial or a jury trial?
A jury.
All right. Ms. Ferguson, drug case 2 days.
Actually, he has 2 cases, Judge, 2 different indictments.
Okay.
I can do the
What by count?
Okay.
October 28th.
October 28th?
Yeah.
All right. So your jury trial date and plea deadline date is going to be October 28th. Once you sign the reset form, you are excused. All right, thank you. Jose Yanes. Good morning.
Morning.
Thank you for dressing appropriately for court. All right, where are we on discovery?
We've received the appropriate discovery, Judge, since our last setting. This was a discovery.
Just to
compliance
make
setting.
sure. So you have all the discovery.
I do. I've learned a lot about this case.
All right, so state, I'll need an acknowledgement of discovery. Was the state able to tender an offer?
They were able to tender an offer today, for a plea, 4 years
Oh,
deferred.
no, I don't need to know what the offer is. I'm not supposed to know.
Okay.
All right, Ms. Ferguson. Can I have a 2-week reset for a plea 3-week reset for a plea deadline date, please?
The paperwork with you.
Well, I did start filling it out because you asked me to, but we're fine coming back for that.
Jill, why am I calling the case then?
Because you wanted to ask for more time.
Oh, no.
We were gonna have.
I wanted a plea reset.
Oh, no. That will be done today.
We want to do a plea today.
Yes.
Okay.
All right, thank you.
Can we do the plea reset? Can we do that? Can we
No,
come
I
back?
mean, we're gonna take his plea today.
All right.
All right, thank you.
Thank you.
All right, Austin Young. All right, so my understanding,
Oh, he's in trial, Judge.
all right,
Disregard.
your attorney is in jury trial.
Yes.
So we're gonna reset you in 3 weeks. Let me see. Why is this pulling up as no? Let me see. Okay, this case number is not pulling up for me.
It has a W, Judge, at the end.
No, I put the W in. Let me see, maybe cross my fingers.
You have to put DC.
All right. Norma, set this in. State, will you be ready in 2 weeks is this gonna be a contested hearing or something?
I think it is.
I have it down as a contest.
All right, Norma, if you'll set this in 2 weeks for a contested hearing, it's Austin Young. State, will you be ready?
I believe we'd be ready 2 weeks, Judge.
All right.
September 11th.
All right, September 11th. Once you sign the reset form, you're excused, and thank you for dressing appropriately for court.
Thank you, Judge.
You're welcome.
Brandon,
Brandon
I cannot pronounce that last name, Judge.
Caskell.
McCaskill.
We're having, we have an offer now. We're asking for one reset and we're gonna come back and I believe accept the offer at the next reset.
All right, how much time are you asking?
30 days,
All right, Ms. Ferguson.
maybe 40.
All right, Ms. Ferguson, if I can have a 30-day reset.
I can do September 30th.
All right, September
I'm
30th.
out of town that week. Can we come back to can we come the week of October 6th, if we can?
All right, Ms. Ferguson, the week of October
I
6th.
can do October 6th.
Okay,
All right, so here's the thing. Court starts in here at 9 a.m. You need to be on time at 9 a.m.
Yes.
You understand? All right, Norma, if you're given the reset form, once you sign that, you're excused.
thank you, Judge.
You're welcome.
Here,
Thank you
Brandon.
so much.
You're welcome.
Give me your order.
Kelly O'Gara, who's the attorney? All right,
That is so he's not far.
he's not far, yeah. He wouldn't leave that behind.
Can you do another one, Judge? Can you do a reset for someone that didn't show up?
Who didn't show up?
Jeremy, is it Jeremy?
Yes, ma'am.
All right,
I'm looking for the page, Judge.
all right, just let me do this and then I'll take that.
Oh, I didn't see Cornelius.
Yes.
Sir.
Hello.
We're looking, Judge, right?
They said they knew you had not left because you left behind your cap.
My cat, I can't get far without.
All right, are these applications?
Yes, sir.
And is there gonna be sentencing today?
Uh,
Or is it
I think, well, it's a, I think.
It's a recommendation?
It's a recommendation.
All right, the court is calling 2025 CR 0075662B and 2025 CR 009816 State versus Kelly Aguero. Could I have parties announced?
Jason Garrett for the state, Your Honor. Fernando for the state as well.
I mean, it's Castro Lopez defense.
All right, so off the record for a moment. So they don't have the W to signify waiver numbers anymore?
Clerk told me at the last setting, we did this, but they don't do that.
Okay,
Unfortunately.
all right, just so I can know where we are. All right, we're back on the record. And cause number ending in 1-6, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.05 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
And did you understand that?
Yes, ma'am.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial? Your attorney has certain rights. Also, the right for the passage of 2 days once he's presented with the information and 10 days to prepare for trial. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
In that cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, sir.
In each cause number, the court will find that the state is in compliance with discovery. Miss, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the court admonishments in each of these, state?
Yes, sir.
Just one moment. I'm just trying to find a document. All right, we're off the record. Defense, did you all get a copy of the information?
Yes, sir. I think
All right, to
Gave
the
it to
clerks, I
the
don't have a
clerk.
copy of the information.
She stepped out, Judge.
well, I don't think this is the original. I thought I gave them the
Let's
copy.
see that and I'll hand it back
Yes,
to
ma'am.
you. All right, we're back on the record. Did you review the information in the cause number ending in 1-6 with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
And state you're proceeding on the information as presented?
Yes, Your Honor.
All right, and then in cause number ending in 6-2B, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No objection.
And each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 1-6, you are charged with placing a child in imminent danger of physical and mental impairment by having child in an environment with access to illegal substances. Here, our counsel. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 6-2B, you're charged with possession of a controlled substance penalty group 2, 4 to 400 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison with up to a $10,000 fine. If for any reason the court were to grant your application for deferred adjudication, if for any reason that deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent. By entering into this pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Aguirre, on each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Did you understand if you're not a United States citizen, then you could be deported, denied naturalization, and not allowed re-entry into the United States by entering into this agreement? Did you understand?
Yes, ma'am.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the cause numbers, in one, your fine is $2,000. The other is $1,500. The cases will run concurrently. And there is to be a recommendation of deferred adjudication. And there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea in each of these cause numbers?
Yes, ma'am.
Defense?
Yes, sir.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
So, Your Honor.
Outside the agreement in the drug case, the state is requesting that your term be for 6 years. There'll be a TAP evaluation, 200 hours community service restitution, parenting classes. In the state jail felony cases, the state is requesting that your community supervision be for 2 years, 100 hours community service restitution, no contact with Layla Aguero, parenting classes, TAP evaluation, and follow all recommendations in the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
All right, then, and
There's a minor that was done, I guess, after hearing the paperwork. As far as the no contact, where the agreement is now, does this, it was, I guess, continued from the last sentence for CPS record purposes for us to do, other than, and determine what happened at the CPS hearing. So to make it easy, we are agreeing with defense that she can't have contact with the children, but there just be monthly field visits for the entire 2 years of the perjury case. So
why did y'all ask probation if they want to do monthly field visits?
I did, and it was indicated to me that that would be something they could.
All right. So they're asking then for no harmful or injurious contact with Layla Aguero. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? All right, then in cause number 2025 CR 0056, I'm sorry, 7526B, how do you plead to count two?
No contest.
And cause number 2025 CR 009816, how do you plead?
No contest.
State any evidence.
Regarding both cases, your Honor, state off proven the evidence cases, one, both have things.
No objection.
And each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication in each of the cause numbers. So when is the co-defendant scheduled in this case for sentencing?
Tomorrow.
For the other one, for some of this one, we got reset for a week's use to.
No, I mean, the one that, so this is a case where Suzanne Kramer is the defense attorney
That one's
Tomorrow.
tomorrow. All right, counsel, are you able to come back tomorrow?
I can, Judge. What happened, if the court recalls, originally I wanted it for that same day.
Mhm.
But I guess it wasn't possible when we reset it.
Okay.
But if I need to come back, Judge, I'll come back.
All right, if y'all can come back, and what I can tell you, this is what I'm going to request. See if the CPS caseworker can zoom in, so the court can see what's going on.
I think they keep, the state can
Have
make
those,
a profit, Judge, if they completed everything.
here's the thing, in some situations, I don't like proffers, because people need to be on the record for what they have done.
Oh.
Yeah, so
see if we can get this.
All right, and they can appear by Zoom?
Okay, that's fine.
All right, so we'll bring you back tomorrow for sentencing. And sentencing will happen on that day, all right? Once you sign the reset form, you're excused. You're welcome. All right, and Brenda, who's your person?
I had a hearing ticket.
Let me see what page he is on.
He's on page 9, 6 down.
Your Honor, he was a hired fine on NTR. We had contacted the family yesterday, and we can't get a hold of him today. We are on the bond. We're asking the court to increase bond.
All right. Court is calling 2022 CR 3839 State versus Jeremy Joseph Duke or Duque. Could I have parties announced?
Brandon Lopez from Mr. Duque.
All right, this hearing was scheduled at 9 a.m. It is now 12 p.m. Counsel, have you had any contact with your client?
We have not today, Your Honor. Yesterday, we had contact with him and his family, and nobody's been able to get in touch with him this morning. So we're trying to figure out what happened.
All right, Deputy, did you make an announcement?
Yes, sir.
And what are the results? All right, State, what is your request?
We asked that you increase bond and issue a warrant.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
You're welcome. All right, come forward, sir. We're gonna recall your case for Thursday. If your attorney is still gonna be in trial. Yes, if he's gonna still be in trial, let him know to contact Ms. Ferguson on the 27th.
Okay, can I, make it's a question. You asked me to do the support things, and every day since I left from here, they had me set up for an in-person assessment for lifetime. But every day since I left from here, I keep calling them. I've never got a call
No, that's
back.
lifetime, but your sober support meetings are not associated with lifetime. So
You had informed me that they had that available, but I guess they're waiting for my in-person before they call back.
okay, well, you should be doing your sober support meetings wherever you can do them. You understand?
Yes, ma'am.
All right, Ms. Ferguson. So we're going to recall him for Thursday and we'll see if your attorney is available at that time.
Also, my job offers wellness programs, and I believe one of them is a drug thing. Would that be acceptable to
You'll
the
need
court?
to speak with your attorney about that.
Okay.
All right.
Thank you.
You're welcome. Thank you for dressing appropriately for court. So they're going to recall you for Thursday and we'll see if your attorney will be available.
And he would contact me, or
He'll contact the court and let us know if he's still in trial.
What we're gonna do with this one?
All right, then what we'll do is we'll reset it.
Okay.
Norma, I need a 45-day reset on Noah Nellam. He's in another county and he's been deemed incompetent. All right, who's here on Manuel Rodriguez? All right, and is there an application?
There you go.
Good afternoon.
Good afternoon.
All right, the court is calling 2025 CR 008497 State versus Manuel Rodriguez. Could I have parties announced?
Tony Hernandez on behalf of Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
We have that.
Court will find that the state is in compliance with discovery. Ms. Abrams, this is an application. Mr. Rodriguez, did you review the application for community supervision with your attorney? Did you understand it? Did you sign it?
Yes.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Rodriguez, did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places? You're charged with driving while intoxicated third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering a plea to this cause, you could be deported or not allowed re-entry into the United States or naturalization if it's determined that you are not a citizen? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication. The state would oppose your application for deferred adjudication if there were one. And the state recommends community supervision. And there's to be $60 to DPS for testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
That is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 200 hours of community service restitution, and VIP live. Did you understand those were recommendations from the state? And the
Yes.
court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objections, Your Honor.
All right. And state, with regards to jail time, do you have any objections to GPS as opposed to jail time?
No.
All right. Thank you, state. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of written witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything that you wish to say on behalf of your client?
Your Honor, I would point out that this case has been pending for quite a while, and he's had no violations that have come across indicating that he's in any way violating the admission interlock order. He's also been on monitor since released on bond for some apparent reason, and he has no violations on that either. We would ask the court he is working full time. Yeah, he does stocking for, is it Walmart? Sam's, I'm sorry. Sam's Club, and he is employed full time. We would ask the court to follow the agreement.
All right. So do you have any children?
I have a boy, he's 24.
Okay, any grandchildren?
Not that I know.
Hopefully, he would tell you.
Yes, I hope.
All right. So it's obvious to the court that you have an alcohol problem because you're here for your 3rd DWI. You're one of those people who cannot drink at all. I don't know anybody that I've ever represented, and probably counsel anybody that you've ever represented who will say, you know what? After I get off at work, I'm going to go have a meal and I'm going to drink myself to intoxication, then drive and kill somebody. Nobody ever, have you ever had anybody to say, nobody ever says that. Okay. You know what ends up happening? You will represent a client sometime who has gone out, had a meal, drank alcohol, is intoxicated, hits somebody, kills somebody, or injures them, and then they come to court crying about how sorry they are. So you are one of those people who cannot drink alcohol at all. And you should have learned that at the first DWI and the second DWI. And now we're here with the third.
I'll make one sober.
Well, congratulations. You know, it's one day at a time.
I'm doing right now.
People, places, and things. All right.
Lost 25 pounds thanks to it.
Oh, see? Well, I don't even drink. I don't know why. It doesn't help me, but okay. Well,
I'm looking forward to doing better, so.
So how are you maintaining your sobriety? What are you doing?
I'm working and that's keeping my eye on that. I work 12:30 to 9 and I don't even think about drinking.
Well, here's the thing, because at some point hopefully we all will retire and you will have free time. So you're gonna have to figure out how do you maintain your sobriety when you have a lot of free time. You understand?
Yes, I hear it.
All right. The court is going to sentence you to 2 years in the prison, suspended and probated for 4 years. There's a $2,000 fine that will be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. There's to be $60 restitution to DPS. All right. So with regards to DWIs statutory, you have to do 10 days in the Bexar County Jail or something else, right? So here are your choices. You can do your 10 days in the Bexar County Jail. It'll start today. Or I can keep you on GPS. And if you're going to be working, it will be partial GPS, and I'll do partial GPS for 20 days. The reason why I'm doing 20 days other than the normal 30 that I usually do is because that he's been on GPS for a while.
Thank you.
So what do you prefer?
Like GPS.
All right, there's to be 20 days partial GPS in lieu of the 10 days at Bexar County Jail. And that's for employment only. So what that means is if you're driving down the street, then, and you see Burger King or something, you're like, you know what, it's right next door. Let me stop there. You're not allowed to do that. You're only allowed for 20 days to go from work to home and work to home. You understand?
Yeah, that's what I've been doing.
All right. And for the record, I'm giving him the 20 days partial GPS in lieu of 10 days at the Bexar County Jail due to several reasons. One, my understanding, the 4th floor flooded. That water came down at South Tower. So there's probably mold or something behind the walls. I don't know if they dried it out yet. And there are, I'm not sure if they still have the recluse spider outbreak over there. And there is also COVID. All right. So that is why I'm not doing it. And I have to put it on the record.
Okay. We need
All
one
right.
of those three would be enough.
There's to be the VIP live, DWI education course. State, how long did you want ignition interlock? All right, ignition interlock for half the term. 200 hours of community service restitution. So you're gonna have to do 200 hours of community service restitution, or I will deduct an hour for every sober support meeting you complete. Field visits, 1 time per month for 6 months. Probation, is there anything else?
Oh, the GPS, that gonna be, is that gonna, the fees gonna wait?
Yes.
Okay, Judge, thank you.
All right, is there anything else you need from the court in order to be successful?
No, man.
Oh, and I'm sorry, Ms. Abrams, we can do a TAP evaluation out of custody.
Okay.
I mean, it seems that he is maintaining his sobriety, but, and if you could let them know, please don't let that interfere with his work. If he can do it by Zoom, great. All right, I'm sorry.
I'm at work on doing my community service, so like, will y'all send me somewhere to go do my community service? Do I have
Probation
to-
will let you know. So you have a
Okay.
choice. You can do the 200 hours community service restitution, which it's hot. They're probably gonna have you outside picking up trash or something. Or you can work on your sobriety and do a sober support meeting. So if you were to do 200 sober support meetings, then your community service hours will be deemed satisfied. So it's up to you.
Okay.
All right, is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to your attorney. Do you understand? All right, we can go off the record. To be successful on probation in this court, communication is key. Whatever you do, do not stop reporting, do not fall off by the wayside and we don't know where you are. If for some reason you think you're about to take a drink, pick up the phone. You can call your probation officer and you know what they're gonna tell me? Hey, he's saying that he may take a drink and I'm gonna have a compliance hearing for you to come in to see what we can do to get you past that point. You understand? But if you just disappear, you can't help somebody who disappears and won't help themselves. You understand? All right, probation will go over conditions with you. All right, good luck.
Thank you, Judge. Maybe excuse.
Yes. All right, Ted Cantu Kalunga. Hello. Hi. Thank you for dressing appropriately for court. Well, today is your plea deadline date. So is this going to be a jury trial?
Not yet.
I mean, it is unless you all have worked out something.
We are in the process, Joe.
Well, Judge, Mr. Burr brought some information to me, on this setting about a civil suit with the victim and the defendant. And he's gonna supply that information to me. I need to contact the victim on that because it seems that it would be damaging or possibly very, useful for us to go forward on the case. So I don't mind setting it off for trial. If everyone, I can check that out and determine whether we're gonna proceed forward with the case or not, Judge.
All right, Ms. Ferguson. Yes, sir. I need a jury trial date on this case. Okay. How long do y'all expect it to last?
I mean, if you want to trial on this, Judge, it's probably 2 days, 3 days at most.
November 12th.
All right, November 12th will be your jury trial date.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Okay.
All right, Roxanne Gonzalez.
Defense counsel said here, defense counsel.
Okay. So where is she?
Let's show. He asked me that he got in contact with her and told her to come here.
All right, Roxanne Gonzalez. All right, could you make an announcement in the hallway for Roxanne Crystal Gonzalez, please? All right, Ms. Ferguson, if you let defense counsel know that a judge's warrant is going to be issued, and if she makes an appearance, the court will reconsider. And is she out there? All right, the court is calling 2025 CR 00373 State versus Roxanne Gonzalez. This hearing was scheduled at 9 a.m. It is now 2:09 p.m. The defendant has not made an appearance. And Deputy, did you make an announcement?
Yes, Judge.
All right. And Ms. Ferguson, did the attorney let her know to be here?
Yes, ma'am.
All right, state.
Judge, we're asking for, I guess, is it a forfeiture or judge's warrant?
All right, the court will issue a judge's warrant. If she makes an appearance, the court will reconsider. All right, Gilbert Avalos, if you'll come forward, please. Hello. All right, so your attorney is stating that they didn't have notice today of this setting. So we're going to recall you for tomorrow. Are you employed?
No.
All right, so we're going to recall for you tomorrow And if you'll sign the reset form, then you're excused. And thank you for dressing appropriately. All right, just stand there and they'll give you a reset form. Yes. Oh, it is, it's not a, it's usually used when for me personally, I don't want to forfeit the bond. One, because the attorney is not here. And two, sometimes maybe someone doesn't have a notice of something, and it's easier if I do a judge's form as opposed to forfeiting the bond. Because if I forfeit the bond, then sometimes the bondsman or, you know what, you've already forfeited the bond. I don't want to be on the bond anymore. And then they'd have to find another bondsman and pay again. And I don't like doing that. Anyone else?
I guess on page 9. First one sentence. But that council is asking if we can do the call for tomorrow. They come from the daughter school. She needed to be picked up.
All right. So Deputy Laura,
Yes, sir.
if you let Mr. Ross, James Ross.
He's out here, Jim.
All right, Mr. Ross, we're going to recall you for tomorrow. Your attorney had a medical emergency, a medical family emergency.
15.
All right, Ryan Rios, if you'll come forward, please.
Ryan, this is your paper. Your attorney's to come here.
All right, we're going to bring you back on September 15th. Your attorney is out ill, okay?
Okay,
Are you in school or anything?
no,
Employed?
I'm trying to get a new job.
All right, if for some reason you obtain employment before that date,
Yeah, and then I got,
you can call in and we can have you present by Zoom since it's for a restitution hearing, okay?
okay.
All right, thank you.
Would I get it on,
You're gonna get a reset form.
would I get it on email?
Your attorney will be able to give it to you. All right, Philip Sanchez. And counsel, are there applications?
Yes, Your Honor, for probation.
All right, probation, there's an application in this case. Court is calling 2025 CR 008548 State versus Philip Adrian Sanchez. Could I have parties announced?
Renee Munoz on behalf of Mr. Sanchez.
And are you Mr. Sanchez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
That is correct, Your Honor, yes.
Court will find that the state is in compliance with discovery. Mr. Sanchez, did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the enhancement received solely on UCW with a felony conviction.
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with unlawfully carrying of a weapon with a felony conviction as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand that if for any reason it's determined that you're not a U.S. citizen, by entering this plea, you could be deported, not allowed re-entry into the United States and denied naturalization.
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's $1,000 fine. State recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be 200 hours of for a term of 4 years.
Yes, Your Honor.
I'm seeing if everybody's awake.
Yes.
And that there be 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Into the offense as charged, how do you plead?
No contest.
State any evidence?
Yes, Your Honor, state offers what has been marked as State's Exhibit 1 and all attachments.
No objection by defense counsel.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor,
Anything you wish to say on behalf of your client?
we're asking the court to follow the agreement, Your Honor. There's issues with the case in terms of the evidence linking to a certain degree. But my client does wish for the plea agreement to be accepted by the court. It's my understanding he has a hold as well. So we're asking that the court just follow the agreement for the community supervision judge.
Here's the thing, when people don't want you anymore, they don't want you anymore. If somebody is cheating on you, then you have 2 choices to make. Either you accept it, or either you say, you know what? This is not what I think a relationship is. I'm going to leave. You do not put a gun to your head and threaten to kill yourself. And now you have a revocation hearing that's scheduled
It's yes, Your
for
Honor.
parole. Now that's what's happening to you, and you have this case. So are you still in a relationship with her?
Right now, I mean, we're talking, but not really, no.
All right, that's going to be a no for the court. So I can tell you right now, I'm going to order no contact with her because obviously that is not a good relationship for either party. Anytime someone threatens to kill themselves because somebody is cheating or somebody wants to leave them,
I was pretty drunk, man.
I don't know anybody. Here's the thing, who gets so intoxicated that they will put a gun to their own head.
Dating, right?
See, and so that's not a relationship for you. And I think your loved ones probably feel the same way. Do y'all have any children together?
No.
And then that's the other thing. When you go to prison, I don't know why people expect for people to wait for them. Nobody's under any obligation. I'm supposed to put my life on hold for 3 years because you did something silly and you're in prison. No, nobody has to do that. If somebody decides to do that, hey, great. But they're not obligated to. Life goes on when you're behind bars. You understand?
Yes, ma'am.
All right. Are you employed?
Not no more.
Well, I mean,
I mean,
previously, were you
yes.
employed? Doing what?
With Millburger.
Okay.
Yeah, Millburger, Mishler.
Okay.
Yeah.
And do you have any children?
Yes, ma'am. They're all grown.
Any grandchildren?
Yes, ma'am.
What are their ages?
She's about to be 1 next month on the 4th.
All right. As previously stated, the court is finding you guilty and states you may be excused. The court will sentence you to 2 years in the prison, suspended and probated for 4 years. There's $1,000 fine. That will be probated. There's to be no unsupervised contact with minors. And there's to be no contact with Jackie, Jackie, Vega, Vega. There's going to be 200 hours of community service restitution. I'm going to order anger management. Once that's completed, the community service hours will be deemed satisfied. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Field visits 1 time per month for 8 months. Probation, is there anything else?
You're doing a TAP evaluation?
All right, we can do, you know what, we can do a MIC evaluation and TAP evaluation in custody.
Your Honor, if I may be heard on that.
Yes.
I know that he does have a hold, and I do know that he was maybe anticipating expediting this process by, you know, waiving his right to trial and taking the plea offered by the state, so we can answer to the charges in the other jurisdiction. Judge, foreseeably, I think that if those evaluations are in custody, it's going to keep him here in custody with the recluse spiders, the mold, and the water issues longer, and then he still has to go as he has a hold to answer to those. So we would ask.
I thought he was on parole.
It's a hold.
Yes.
It's my understanding.
It's federal probation. It's for this.
Federal hold, Your Honor,
Federal
on
hold.
probation.
Oh, so he has a federal case.
Yeah, it's my understanding. He clarified that. He did say he had a hold, but it seems like it's a federal hold within that jurisdiction. So I know the feds are waiting for this matter to be resolved to see if they're going to revoke or to keep him on probation federally, which our hopes are that, you know, if he's on probation here, they can be on probation as well with the feds and
Well, I
escape.
can say usually it's probably best for him to be evaluated for competency. So the feds can say he's getting help from mental health. But if you are requesting that the MIC and TAP evaluation be out of custody because he has the federal hold, the court will do that unless there's some objections. Probation, your thoughts?
No, that's fine, but we can go outside of that.
All right.
Thank you.
So that'll be done out of custody. Is there anything else you need from the court?
No, that's it.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you are not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So this is what ends up happening. When people go to prison or if they end up getting revoked, they forget about their probation. And then what ends up happening, a motion to revoke is filed. Then they have this pending. If they decide to continue you, do not forget about this probation. So the first thing you need to do if you're released is to check in with probation. And if they do revoke you, you need to speak to your attorney because then maybe there's something else that can be done with this case.
Yes, Your Honor.
All right, good luck to you.
Thank you.
All right, Josh, Jose Yanez. And probation, this is an application. Court is calling 2023 CR 8715 State versus Jose Yanez. Could I have parties announced?
Jason Garrett for the state, Your Honor.
Charles Butcher for the case.
And are you Jose Yanez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, I did, Judge.
Court will find that the state is in compliance with discovery. Mr. Yanez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
And is he applying for deferred adjudication or regular probation?
It's a deferred case, Judge,
Okay.
for the state.
All right, so they're applying for deferred. Did you review the true bill of indictment with your attorney?
Yes.
I have the other one. They just did too. Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, I did.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with failure to stop and render aid. All right, so it's been indicted as a state failure to stop and render aid with a moving vehicle with an accident that was reasonably likely to result in injury or death. The range of punishment for that is up to a $5,000 fine, up to 1 year in the Bexar County Jail, or up to 5 years in the prison. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Sure.
Did you understand if the court were to grant your application for deferred adjudication, if any reason your deferred adjudication were revoked, the court could sentence you potentially up to 1 year in the Bexar County Jail or up to 5 years in the prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, and he was.
Mr. Yanes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your, oh, I'm so sorry, because they changed the paperwork. All right, did you understand that if you were not a citizen, by entering into a plea in this case, you could potentially be deported from the United States, not allowed re-entry or naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication, and there's to be restitution to Salvador Garcia. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is one.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
We don't have any of those motions.
All right, outside the agreement, the state is requesting that your community supervision be for a term of 5 years. And state, did you all initial this?
I did initially.
All right, thank you. I'm having a problem reading that. That's okay. There's to be a TAP evaluation, 200 hours community service restitution, no contact with the complainant, and the driver's safety course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead?
No contest.
State, any evidence?
No.
Any objection?
No.
All right, did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
A number of things. Basically, what I want noted is that Mr. Lanas was only 21 years old the day of this incident. This is his first offense. He has no priors. And the day of incident was August 28th of 2021, and the indictment was filed quite a bit later. And as far as the probation term, I think we had a little bit of a, well, we weren't too sure. We think if it's just a bodily injury case, it's a state jail felony as the maximum wage punishment. From my review of the discovery, this man didn't use an ambulance. Mr. Lanas did return to the scene, gave an oral report to the officers, and he wasn't arrested at the scene. It wasn't until later his girlfriend got in an accident. That's how he got caught and found out that there was this indictment. So with that in mind, that this is his first offense. He hasn't had any other accidents since. It's probably the best I could tell you about his punishment.
So are you employed in school? What are you doing?
I am not employed anymore.
So what do you do?
I'm trying to apply to go back to college. I stopped to.
All right, are you trying to apply or have you applied?
I have applied.
All right, so have you received an acceptance?
Nothing yet.
Where have you applied?
To Northwest Vista.
Okay. And when did you apply?
This was in July.
Okay. This July?
Mhm.
That's keeping things a little bit late.
Yeah.
Because don't they have deadlines?
I stopped going to college to pursue like music.
And how's that going?
It's going all right. It's just I just kind of wanted to just go back to school.
When you say pursue music, how are you pursuing music?
Like I play the drums for a band.
Oh, what's the name of the band?
It was called Lead Hate.
Lead Hate?
Lead Hate.
Oh, lead.
Yeah.
Okay, like Leadfoot, Lead Hate.
Yeah, yeah.
Okay.
It's supposed to be like slow heavy metal music.
Okay, I've never heard of slow heavy metal music. I love all types of music, so I love being educated.
So it's like, Black Sabbath.
Yes.
Ozzy Osbourne. It's kind of like
wear Black Sabbath.
It's like that, just like physically heavier and much slower.
So not that heavy.
Yeah, pretty much not as heavy.
Okay. All right. So since you're not pursuing that anymore and you're not in school and you're not working, what do you spend your time doing?
Practicing my drum set, taking care of my grandpa at home.
I'm sure your grandfather wants you to do more.
Yeah, he does.
So you're gonna have to do more.
Yes.
All right, this is what the court is going to do. Oh, just as a side note, why didn't you just stop? If you would have just stopped, we wouldn't even be here.
I know. I was like 5 years ago. I was just a big
So you were
shock.
just like, oh my gosh.
It was just like, oh my God, like I was just so scared and shocked that I had to go let my boss at Chick-fil-A know, and then I came back to the scene.
Okay. All right, the court will sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment or enrollment in a university within 45 days. There's to be no employment as a home health care provider with minors. So probation, he can either be enrolled full-time in college or have employment.
Okay.
And for this court, I'm not going to require you to be enrolled in college the way I was enrolled in college. Because each semester I would take 21 to 24 hours because it was cheaper. So you need to take at least 8 hours a semester, you understand? For it to count with the court.
Yeah.
All right, there's to be 200 hours of community service restitution. That will be deemed satisfied once you complete the driver safety course. And does anyone know if there's restitution to the complainant?
Judge, we reviewed this case with the prior DA, and also Chick-fil-A had insurance on this accident. And that was, in other words, the civil matter regarding the car accident was settled.
Okay.
So there's likely not going to be any further restitution to the complainant.
There's to be restitution, if any, to Salvador Garcia and no contact with Salvador Garcia. There's to be field visits one time per month for 6 months. And Ms. Ferguson, if I can have a 30-day reset for a restitution hearing.
I guess.
And if you all discover that there is no restitution, if you bring it to the court before then, there'll be no need for a restitution hearing. September 25th. I'm sorry, State, you may be excused. Did you review the probation? Is there anything else?
No, thank
Is there anything else you need from the court to be successful?
Just a question. So does that have to be for the one or the other, like the school or the job? It has to be one or the other or both?
One or the other.
Okay, I was just curious.
But let me just tell you, in this court, if it's going to be one or the other for you, then that means you're a full-time student. And for this court, full-time student means at least 8 hours per semester. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Yes, Your Honor.
All right, if there's anything you need or you have any questions about anything, let probation know. If you feel as though probation is not addressing it, you can always come back to the court. All right, just have a seat and probation will go over the conditions with you.
Thank you, Your Honor.
You're welcome. Have a good one.
Thank you, Judge Wood.
You're welcome. Rodney Brown. Hello, sir. We're going to recall your case for tomorrow. Your attorney, there was a slight miscommunication and he thinks you're set for tomorrow instead of today. So we'll bring you back tomorrow, okay? Oh, what's going to end up happening is tomorrow your attorney will let me know. Because your attorney will have to present that to the court. Oh, he's going to contact you tomorrow. He'll be here. All right, thank you. All right, who's here on Ruiz Ortega?
That's me, Judge.
All righty. Is he here?
He's right in the box.
Oh, he needs to come down. Hi, how's it going?
Well, thank you.
All right. So where are we on discovery?
I just got the disclosure, the discovery acknowledgement, Judge. It's very voluminous. I don't know how many entries, but it's very thick. There's a lot of medical records in it, and I need to go through it. This is the first setting we have, so I just conferred with Mr. Garhan, and we signed the discovery acknowledgement, and we just need a reset to review all the discovery.
All right. So you've signed an acknowledgement?
We did, Judge, and already filed it with the court.
So how much time are you requesting?
It's pretty big, and I have a lot of cases, so 60 days will be good.
See, you asked for the world. See, I thought he was going to ask for 90 and I was going to say, okay. But,
I'll do 90. I'll take 90.
but since he asked for 60, no, based upon what I can see, the nature of the charge, I understand there's probably a lot of medical records.
Right.
So Ms. Ferguson, if I could have a 60-day reset for the defense attorney to review discovery. All right, thank you.
October 23rd.
All right, and State, do you think you'll be prepared to tender an offer at that date or no?
And the state will.
All right, what offer will you do on that date as well, Ms. Ferguson?
October
23rd.
Yeah, I'm here. Okay.
All right. So is there anything else? Do you have any questions, sir?
No.
All right, thank you. That was a long pause. And it's like, no. All right. Oh, you'll have to talk to them. So that some of them will ask to be paused because, for example, you can't have a defense attorney who has 1,000 cases pending because then they can't represent anyone. So it really depends on the defense attorney, and we don't have enough attorneys. So how many cases would you say you usually have?
Handle, like throughout the year or per month or just at
I'm
one
trying
time?
to figure out how heavy is your caseload?
Okay, if obviously fluctuates, and sometimes I'll get a client with multiple cases too, so that kind of does skew a bit. But I would say at any given time, over 100 to 110 cases. Where you resolve some, then you get assigned new cases, so that constantly is in flux, yeah.
All right, the court is calling 2025 CR 002-899 State versus Richard Ibanez. Can I have parties announce?
Lawrence knows for the state.
Renee Munoz on behalf of Mr. Ibanez.
Oh, Deputy Laura, could you move into the end? And are you Mr. Ibanez? All right. Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
I have, Your Honor.
And probation, this is an application.
Okay.
And Mr. Ibanez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Okay. Court will find that the state is in compliance with discovery. Mr. Ibanez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it and cite it in all the appropriate places?
Yes, I did.
You're charged with theft of property, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to a $10,000 fine and up to 2 years in the state jail facility?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct.
Mr. Ibanez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you have been represented?
Yes, yes, I am.
Did you understand if you were not a U.S. citizen, by entering this plea, you could be deported, not allowed to re-enter into the United States, and be denied naturalization?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication, and they're taking in consideration 2025 CR 009645. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yes, ma'am.
Did you understand it and sign it in both places?
Yes, I did.
Oh, you can cross over.
I'm just
Yeah,
gonna read
sure.
it again.
All right. You're welcome. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours community service restitution, and no contact with Mary Escalona. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead?
Yes.
State, any evidence?
Yes, Your Honor, state offers what's been marked as State's Exhibit 1 in all attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, I did.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements
Yes,
and police reports, but most importantly, there'll be no live testimony. Did you understand?
yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
If we may, Your Honor,
Anything you would say on behalf of your client?
respectfully requesting this court follow the negotiated plea bargain agreement, Judge. I know that there was an issue with the U-Haul. My client states that he had lent it out to another person who was supposed to have turned it in. That was probably ill-advised, not the best judgment to rely on someone to carry through his contractual obligation. Needless to say, the truck has been returned to U-Haul as per ADA Megan Galloway. So U-Haul did receive the truck, and don't believe there's a restitution amount now as to maybe some of the profits they may have lost out on not having usage of the truck, Judge. There was another case also associated with Mr. Ibanez. He came into court today to answer for the theft charge, and it seems there was a fraudulent use charge that was indicted. Client states that he unfortunately had to resort to dumpster diving to sustain himself. He's fallen on hard times, Judge, but he has indicated he does not have substance use issues or mental health issues. He's just monetarily struggling. We're respectfully asking if the court does follow the agreement that the $1,000 fine be probated, Your Honor. If the court sees fit to recall the warrant for the fraudulent use of possession of identifying information, we'd respectfully request that as well, Judge, please.
All right, and that case taken in consideration?
Yes, Your Honor. That's the
That's it, okay. So, are you employed?
No,
So how are you supporting yourself?
I'm diving and scavenging for everything that I possibly can,
Well,
just
do
to
you,
eat, just to eat and
do you
survive.
have a place to live?
I'm working on it.
So where are you living?
I'll try.
Okay. So why did this come about?
You mean
The U-Haul incident?
just someone that I knew said that they maybe need to use one and borrow one, and I was renting actually from storage. I had a burned storage at that time, and I just she talked to me and kind of letting them, renting it for them, and next thing I know, I didn't even know. I was told that they returned it. It was returned with the keys and everything. And a year later, when I got arrested, so I really wasn't kind of aware of how the situation had been. But I was under the assumed that it had been turned in, and that was the deal. I rented it for them, and that was it.
So do you have any family here?
I have a cousin here. That's where I have a mailing address too.
So where is your hometown?
Here.
No, I mean your hometown. Where were you born and
Oh,
raised?
actually, well, I mean, I spent a lot of time here. I have a lot of history here.
So is all of your family in Roswell?
No, my mom was in El Paso, and outside of El Paso, a little town called Van Horn.
Mhm.
And that's where my mom is, and that's pretty much all I have.
So is there anything here for you? Because I will tell you, being on probation is difficult or not. I can imagine it's extremely difficult if you don't have a support system and you're telling me you're living out of your vehicle. Maybe, you want to live where family are.
Been considering that, I moved back here from my daughters. And
Well, I asked you who are your family here and you didn't mention any daughters. So how old are they?
they're old, they're 18 and 28, but I mean, they don't talk to me anymore. I haven't been,
Why is that?
I have no idea.
You have
I've
to
been
know
trying-
why
I've
your
been trying to
children are
figure
not.
that out. Judge, I've asked them, and I haven't gotten any reason why.
Well, let me ask you this. Were you a good father to them?
Yes, ma'am.
And what is your idea of a good father?
I raised them.
All right, so that's odd that they wouldn't talk to you.
That's why me and your mother don't talk very well. I'm not sure if it's, I haven't found a reason why. I'm still searching. I'm still trying to find that out. You're gonna get me emotional. I mean, it's just where I'm at.
So you're saying you raised them, but they won't talk to you?
Yeah, well, I mean, once we got a divorce and stuff, they weren't with her, but we were still in very good terms. When I was in the oil field working and stuff like that, I used to go to Paso and see them all the time. I worked to stay in their lives, you know what I mean? And it just, at some certain point in time, they stopped talking to me, and I couldn't figure out why. I've always tried to be in their lives, but this time, my ex just kind of said that,
Well, I
wasn't
will
gonna
tell
allow
you, you're gonna have to start taking a internal, evaluation of your life and find out whether or not being in San Antonio is best for you. If you decide that you want to leave to be near family, if you let probation know, we'll have to do a transfer of your probation to another place. You understand? All right, but in this court, you're gonna have to get employed. You understand? Court is gonna sentence you to 4 years deferred adjudication. There's $1,000 fine to be probated. Take in consideration 2025 CR 009645. The warrant should be recalled in that case. There's to be no contact with Mary Escalona. Proof of employment within 45 days, no employment as a home healthcare provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. There's to be 200 hours of community service restitution. If you're drug tested today, what are the results going to be? And here's the thing, you're going to get drug tested. What are you going to be positive for? Here's the thing, just be honest with me and tell me the truth. All right, so
I think,
see, and that's the reason why maybe your children don't have contact with you. So you gotta, here's the thing, when I have someone, sure, once in the blue moon, the person their family was horrible to them. Mother turned their children against them. But usually there are other things that are going on. So there's gonna be 200 hours of community service restitution. I'm gonna run a referral to felony drug court, and if you could coordinate that and make sure that he does that, and that's gonna be done out of custody, and you need to make sure that you make that. If you do not, a warrant is gonna be issued for your arrest. You understand?
That sounds good, Your Honor. I'll coordinate with Sean with that as well.
When's the last time you used? Tell the truth. Yesterday?
Well, Your Honor, I know where your concerns are. My concern is that, we're asking the warrant be recalled and the like because my client's vehicle where he's living out of is parked right now, and if he does not answer for that, it's going to be towed and he's going to be in a mess of trouble. So I know that the court may have concerns about a tap in custody, but.
Well, no, I'm thinking about felony drug court. So if you can do me a favor,
Okay.
before he's released today from this courtroom, if somebody can call felony drug court and see maybe if they could schedule an appointment for him tomorrow, or either he can stop over there today because he has his vehicle.
Yes, ma'am.
All right.
I'll definitely reach out likely to Ms. Zamaron to see if those arrangements can be made, judges.
All right. So there's a referral to felony drug court out of custody, tap evaluation out of custody. And if not accepted to felony drug court, then he's to return back to court.
Okay.
And there's to be no unsupervised contact with minors. Probation, is there anything else?
No.
And I'm sorry, field visits 1 time per month for 6 months. Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do. Thank you too, very much.
All right, you're welcome. We can go off the record. You're gonna have to make sure that you stay in touch with probation. If you think you're gonna use, you need to pick up the phone and call probation or call somebody. Do you understand?
Yes, I do.
And I'm so sorry, probation, if you're at sober support meetings for him, and we'll start with 60 and 60 days, and then felony drug court will take over from there.
Yes, sir.
So when you leave here, I'm ordering that you do a sober support meeting today. You understand? All right, thank you.
Thank you, Your Honor.
So a lot of times I will ask defendants a lot of questions because I want them to be successful on probation. And I try to understand what's going on in their life because sometimes people don't open up to you about what's going on in their life. And sometimes if you talk to them about other things, then they'll see that it's not so scary and that somebody's just really trying to help them out. So I'm asking that he be seen by felony drug court to help him with his addiction. Hopefully it works. All right, on Rodolfo Briceño, is this an application?
No, you're.
Okay. All right, we're gonna go on the record in 2025 CR 004541 and 2025 CR 004546. State versus Rodolfo Briceño III. Can I have parties announced?
Lauren Espinosa for the state.
Lauren Lefton for Mr. Briceño.
And are you Mr. Briceño? Counsel, have you received all discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Oh, thank you. And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
State in each cause number, are you proceeding on the indictment as presented?
Yes, Your Honor.
And each cause number, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
In each cause number, you're charged with theft of property, $2,500 or more with 2 previous convictions. Those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each case, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent. Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of the cause numbers?
Oh, yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Briceño, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering into plea bargain agreements in each of these cause numbers, if for any reason it's declared that you are not a U.S. citizen, you can be deported, not allowed to re-enter the United States and denied naturalization?
Yes,
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
yes.
All right, according to your plea bargain agreement, there's a $1,000 fine. The cases are to run concurrently. Punishment is to be assessed at 11 months in the state jail facility. State will take in consideration 2025 PF 11592, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then in the cause number ended in 4-1, how do you plea?
No contest.
And the cause number ended in 4-6, how do you plea?
No contest.
State in each cause number, is there any evidence support the defendant's plea?
Yes, Your Honor, in both cases, state offers would have been marked as State's Exhibit 1 and all attached.
No objections, Your Honor.
In each of the cause numbers, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments? But most importantly, there will be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we ask you follow the agreement.
All right. Why do you keep stealing?
That was a backtrack for me.
Hmm?
That was a backtrack for me. I was staying at a motel. I needed some money. But then after that, I started going to school.
So here's the thing. You have children?
Yes, ma'am.
And what are their ages?
18, 13, 4, 3, and 1.
All right. So your last name is Briceño III. So that means that there was a second and there was a first. So do you have any relationship with Briceño Jr. and Briceño Sr.?
My grandpa passed away. My dad is.
All right. And were they good parents and a good grandfather?
Yes.
You're ruining the name. And then if you have a son, is he the fourth?
Yes.
You're ruining the name for him. Now, your son has all this baggage that they're going to have to try to repair this name. And can you imagine if everybody in this courtroom fell on hard times and our answer to falling on hard times was to go to stores and start stealing? That's what you're doing. And there are plenty of places, and I see part of the things that you were taking were baby formula, diapers, but there are plenty of places where you can get free baby formula, get free diapers. You don't have to go in and steal. And then the other thing is, people want to be fruitful and multiply, fine, but you have to start thinking children are expensive. So how am I going to pay for daycare if I'm going to work or if the mother has to work? Instead of just saying, oh, my dad will watch them or my mother will watch them, because nobody asked them. You understand?
Yes, ma'am.
Children are expensive. You got to pay for diapers. And in your situation, if you can't afford diapers, you know what you should have done? I can't afford diapers, so I'm going to go the cloth route. But nobody wants to do cloth diapers. You know why? Because it's not convenient. It's extra work, because then you got to wash them. You understand? You're going to have to start making better decisions. Otherwise, when you wake up, that 1-year-old is probably going to be 3 or 4 and doesn't even recognize you. And do not let them bring the children to the Bexar County Jail to meet with you. You just heard me say how nasty the jail is. Do not have them coming to visit you at the state jail facility. It's nasty, it's filthy, and you don't want your children to get in the habit of thinking seeing dad behind bars is okay, and that's a nice place to be. You understand?
Yes, ma'am.
All right. And each cause number, as previously stated, the court is finding you guilty. And the cause number ending in 46, the court will sentence you to 11 months in the state jail facility. Give you credit for any time served. This is right concurrent with 2025 CR 004541. Take in consideration 2025 PF 11592. And in cause number ending in 41, court will sentence you to 11 months in the state jail facility. There's $1,000 fine. Time and money will run concurrently. This will run concurrent with 2025 CR 004546. Take in consideration 2025 PF 11592. Is there anything else with regards to sentencing in either of those cases?
No, Your Honor.
All right. In each of the cases, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, sir.
And just so the court knows, These cases were about a year old, and since then he did enroll in cosmetology school and so he is aspiring to do better, and hopefully when he's released, he'll be able to finish that
Oh, awesome.
education. So he is trying.
You know, usually males do very well in
Yeah.
cosmetology school.
Yeah,
That's who you go to for a good haircut, if you're
Exactly.
female. I'm just saying.
yeah, it's true. So hopefully this doesn't derail you totally and you start.
No,
back.
I'm looking forward to getting done and finishing, to get my license.
All right, so let me explain something about getting your license. Both of these cases are what's called crimes of moral turpitude. So when you try to get your license, this is gonna pop up. But it's not impossible for you to get your license, but you just cause an impairment to that, right? But there is someone who graduated from felony drug court, and everybody was telling them, you can't be an attorney. I'm sorry, that dream is dead for you because of all your past. And guess what? He has his license. He's an attorney. It just took him extra steps to do it, and he had extra things to prove to people. So it's not impossible, but you're gonna have to do extra steps. You're gonna have to get letters from people and show that you changed. You understand?
Yes, ma'am.
All right, good luck to you.
Good luck.
Yes, ma'am.
Here's
All right, Counsel Andrade?
Yes, Judge.
Yes.
It's a discovery hearing. I had asked Jason to view a video. The video was obtained. I believe we have all evidence. I was able to show a video to my client. Jason tendered an offer. We're respectfully asking if we can come back tomorrow or Wednesday. Jason put a expiration since he'll be leaving this court. He just wants to make a couple phone calls from the jail.
All right,
Discuss
Ms.
it.
Ferguson.
Oh. Yes, ma'am.
We can bring you back tomorrow.
Tomorrow.
Norma, on Andrade,
Yes, ma'am.
tomorrow. I know.
It's kind of late, Judge, and we already submitted the thing.
Oh, just tell them.
Wednesday. Wednesday or Friday is better.
Thursday.
I can't do
Wednesday.
that
It'll have to be tomorrow.
tomorrow.
We can order them in the morning, whatever. Okay. All right, thank you.
Thank you.
Yeah. All right, we're gonna go on the record in 2025 CR 008393 State versus Danny Ray Williams for the state. All right, this hearing was scheduled at 9 a.m. It is now 3:32 a.m. The defendant has not made an appearance. Request from the state.
Offer Richard or judge's warrant?
Judge's warrant. The court will grant a judge's warrant, remand the defendant without bond. If the defendant makes an appearance, the court will reconsider.